Thank you. Let's come to order for day 2 of the Blockchain Select Committee. We've got another full day ahead of us, Mr. Co-Chairman, and I think we're going to start off with roll. Before we do that, any opening comments?
No, yeah, just glad to be here.
Glad to be here.
Call the roll.
All right, let's do it.
Senator Furphy.
Here.
Senator Cost.
Here.
Senator Nethercott.
Here.
Representative Stith.
Here.
Representative Western.
Here.
Representative Yin.
Here.
Mr. Kaufman.
Here.
Ms. Long. Mr. Reville. Co-Chairman Olson.
Here.
Chairman Rothfuss.
Here.
Everyone's here.
Excellent. Full attendance. All right, so as usual, for those listening, we'll take public testimony on each of the on each of the topics as we go through the agenda today. We'll try and keep that public testimony concise so that we can stay on schedule. And we are closing up on a number of pieces of legislation that we've been working during the interim and hope to be able to bring to the legislative session. Before we get started, Mr. Co-Chairman, in talking with our LSO staff, there was a desire to get a vote on bill draft from yesterday, 22 LSO 258 deregulated industrial power zones, because you, Mr. Co-Chairman, announced a different bill. So we actually voted on an entirely different bill. So just in the interest of trying to be accurate and adopting motions that are relevant, you want to run through that one again? What do you think?
Sure.
Let's do
it. I really thought that bill we passed twice was a good bill, but
It was good both times. But with that, just for the record, let's take roll call on 22 LSO 0258 deregulated industrial power zones, as discussed yesterday. And we had no amendments on it, I believe. So it's as drafted. And with that, please call the roll.
Senator Furphy.
Aye.
Senator Cost.
Aye.
Senator Nethercott.
No.
Representative Stith.
Aye.
Representative Western.
Aye.
Representative Yin.
No.
Co-Chairman Olson.
aye.
Chairman Rothfuss.
Aye.
That passes.
All right.
It was a little different that time.
Yeah, it was about the same. We had Senator Nethercott.
Yeah.
Yeah. All right. Then now that we've got everything cleaned up from yesterday, let's go into today. And we're starting off with DAOs, decentralized autonomous organizations. Our first order of business, if we have somebody hopefully from the Secretary of State's office, is just an update on where we are with DAO filings. As everyone recalls, we went live with our DAO legislation on July 1st, first of its kind in the country, and we've had a tremendous amount of positive feedback. So we're hoping to get an update from the Secretary of State's office on what those filings have looked like and maybe have a little bit of discussion before we go to the legislation, our draft legislation, which is some amendments to that earlier legislation to address some concerns. So with that, I see the Secretary of State's office. If we can get him up on the screen, I see Representative Yin on the big screen, and Zoom really likes Representative Yin. It's attracted to him, and he spends a lot of time on the big screen, whether he's speaking or not. But let's go to the Secretary of State's office if we can.
Good morning, Mr. Chairman, members of the committee. Can you hear me okay this morning?
We can. Good morning.
Good morning. Karen Wheeler, Deputy Secretary of State, and thank you for inviting us today to do an update on DAOs. We're very happy to be here. So as you said, the law did go into effect on July 1st, and at 12:00 a.m. that morning, DAOs could be formed online with our office 24/7. So the first day on July 1st, we did have 21 file with us, and the first one came in at 12:11 a.m. And as of December 31st of 2021, we had 130 active DAOs. 125 of those were new registrations, And 5 were conversions from an LLC to a DAO. And those brought in a total revenue of $12,800. Now, what we are seeing when we look at the filings that come in, I categorize our filers into about 3 different groups. First, you can definitely tell the DAO filings that come in from the filers that are in that industry. Everything is correct on the filing. They know the public identifier. They're very clean. Our second group is your filers that are new to the industry or intrigued by it. Some of their filings are missing information, and we do work with them to get the information that they need to and explain. They do ask a lot of questions, which is great. I think my most favorite is, what is a DAO? I want one. And we're happy to help them get one. And then the third category of filers that we are seeing are those that are filing shell DAOs. So we do have some of those happening. And Mr. Chairman, as of December 31st, we have not had any DAOs file any articles of dissolution. And we have not had any administrative dissolutions, as those typically happen after the first annual report is due and it has not been filed. So as you know, when an annual report is due on an entity, it's due the first day of the filing month the year after they file. So the first annual reports will not be due till July 1st of 2022. And our office does send out courtesy emails to each entity 60, 30, and 10 days before the annual report is due, so the entity knows, hey, you've got this coming up. If the entity does not file their annual report, we then send another notification, hey, you have missed your due date. You have 60 days to file it. If you don't, then in 60 days, you will be administratively dissolved. So we will start looking at statistics in September and October to see how many did not file an annual report. That is kind of telling for us as we look at that with our other entities as well. And so, Mr. Chairman, that is the end of my update, and I'm happy to answer any questions that you or the committee may have.
Excellent. Thank you, Deputy Wheeler. Any questions for Deputy Wheeler? Representative Stith, go ahead.
Mr. Chairman, thank you. Ms. Wheeler, I have a question about the public identifier feature. So if a member of the public sees the public identifier and logs on to that web address and then lands at some homepage for a law firm, I have 2 questions. One is that deemed sufficient to be a sufficient public identifier if you just sort of land at some law firm's homepage? Does that satisfy what public identifiers are supposed to be?
Deputy Wheeler, go ahead. And if you'd actually give us kind of the background on where we landed on appropriate use of the public identifier.
Thank you, Mr. Chairman and Representative Stith. That's a great question. And
Oh, no. I'm so sorry. I don't know what happened.
Deputy Wheeler, I hear a slight voice. I'm not sure where that's coming from though. If
I'm
anybody
sorry.
has-
I'm sorry, Mr. Chairman. If you can still hear me, it appears that we have.
Yeah,
there
we can hear
are.
you.
Sorry.
If somebody else is on, turn the mic off, but we can hear you.
Okay, thank you, Mr. Chairman. So as I was saying, Mr. Chairman, Representative Stith, that is a great question. Our office's responsibility is to make sure that information that is required statutorily is provided in the articles of organization or incorporation, depending on the entity type. As far as the public identifier, I would have to defer to the committee and to the experts in that area as to what is an appropriate public identifier. And we have gone round and round within our office and talking to people in the industry, and there are different versions of what is an acceptable public identifier. Now, to your question, Representative Stith, personally, and please, everybody knows I'm not in this industry, and this has been a great learning experience for me, but if I land on the homepage of a law firm's website, to me, that is not what I would consider a public identifier. But again, I would defer to the experts within that industry.
Thank you, Deputy Wheeler. And Mr. Kaufman, I know that you had a lot of discussion, and we've had other members of our working group that have had discussion on this topic to try to formulate what that identifier is going to look like and what's acceptable for the Secretary of State's office on filing. So it's a little bit in flux, but we're trying to standardize that. The challenge with standardization is that the industry doesn't have a perfectly clear standard yet. So not being flexible would be probably overly limiting. But Mr. Kaufman, do you have any thoughts or additional comments on how that is rolling out in your experience?
Yeah, Mr. Chairman, thank you. Hopefully y'all can hear me okay. I think this is, as Deputy Wheeler said, I think it's a little bit tricky. Candidly, many of the DAOs that we've been working with and hearing from in this space generally fall in two camps. One camp is the public identifier is not a problem because what we're doing is oriented towards the public and something we want people to be able to see and participate in. And for those participants, the public identifier usually isn't that big of a problem. What I think maybe we didn't fully contemplate at the time that we originally drafted this legislation, a few years ago, was that the policy orientation of the statute generally is just at disclosure and making these DAOs provide a little more detail in the articles than we would otherwise require of entities. And I think what we've heard over the last several months from some entities is, okay, great. If we're going to be a DAO operating in a more public manner where we're going to have that public disclosure, we get it. But what if we're not? And what if we want to be more private? Do we still have to provide that kind of information? And then again, to the Secretary of State's point, that's a really awkward position for them to be in, to kind of pass judgment on whether or not these identifiers are good enough or valid enough and what exactly they point to. So, Mr. Chairman, I don't have a good answer for that. I think we as a committee maybe need to discuss just a little bit the conflict between how much public disclosure do we want of these entities. Again, I would maintain our discussion over the past few years has been more on the side of let's ask these entities to disclose a little more than we normally would have an LLC. But maybe we could start to peel that back a little bit, seeing now how people are using the statute.
Excellent. Thank you, Mr. Kaufman. Any questions for Mr. Kaufman or any follow-up, Representative Stiff, on this topic? Great. All right. Any further questions for Deputy Wheeler in the Secretary of State's office on DAO filings? Any online? All right. Seeing none, thank you, Deputy Wheeler, for the update. And hopefully we have quite a few more filings. And we also look forward to follow-ups about the renewals and the ongoing operation of those DAOs. So we appreciate your engagement today.
Thank you, Mr. Chairman.
All right, committee. So the next item on the agenda under DAOs is consideration of our DAO or amendments legislation 22 LSO 0063. And Mr. Hopkinson, I think for the committee's edification, it would be probably good to walk through the entirety of the legislation where it ended up, because quite a few places have changed and it's not that incredibly long. So if we could go through the bill draft and highlight things that are different from previously, but make sure we all understand what's going on.
Thank you, Mr. Chairman. I'm happy to do that. David Hopkinson with the Legislative Service Office, walking through 22 LSO 63 Working Draft 0.7. At the front of the bill draft, page 2, there is a staff comment there that does outline specifically what has changed in this version from the version that the committee did see at the last meeting. And as we come across those, I will call those out to the committee. There's a number of things that this bill draft does. Primarily, it removes the term quorum and the use of quorum throughout the bill. It removes the distinction that was in the current statute between member managed and algorithmically managed DAOs. It adds new dissolution methods. And it gives some new methods for, at this point, either the court or the Secretary of State, but we're going to be finalizing that today. The court, probably, the ability to dissolve DAO under certain circumstances. Walking through the bill on page 3, the changes here to the definition of majority of the members is primarily just getting rid of the quorum, the notion of the quorum, and it provides that the majority of the members is more than 50% of the membership interests eligible to participate in a vote or any membership interest required pursuant to the DAO's Articles of Organization or Operating Agreement. On membership interests, we see a change down here from on line 12 from the term membership's ownership share to members' ownership right. Again, most of those strikings are just getting rid of member managed and things of that nature to really emphasize that a DAO is not just member managed or algorithmically managed. So that provides that membership interest, which may be determined by the organization's Articles of Organization or Operating Agreement, or in new language here on line 15 and 17, ascertainable from a blockchain on which the organization relies to determine a member's ownership right. And that's just to give a little bit broader prospects for what or how a DAO can define that membership interest. On page 4, there's some changes to the definition of smart contract, providing it's just some cleanup language there primarily, and adding in the language script programming language relying on a blockchain. At the bottom of page 4, we see the first change from the last time that we met, adding in a subsection C that provides that nothing in this chapter shall be construed to prohibit a company that would otherwise qualify to form under this chapter from forming under the Wyoming Limited Liability Company Act. And that was just to address a concern that it wasn't clear that a company that could otherwise form as a DAO under the DAO supplement could still form as a regular LLC if they want to. On page 5, the changes here, mostly getting rid of the member managed the distinction in subsection E there. Got a new subsection E.
David, sorry to interrupt, just a quick note on line 15. You've got it's trivial, but you've got a capital M where it's a continuation of the sentence. So lowercase that.
We will fix that, Mr.
Yeah.
Chairman.
Sorry to interrupt, but just noticed that.
The new subsection E for formation provides that if the Articles of Organization filed pursuant to subsection A under the formation section does not include a publicly available identifier, the person filing shall have 30 days to provide that publicly available identifier to the Secretary of State. And if it's not provided within that 30 days, the Secretary of State shall reject the filing and the decentralized autonomous organization shall be deemed to have not been formed. And that is again addressing the issue with publicly available identifiers and providing guidance on how that should work. On page 6, the amendments here to the Articles of Organization, adding that procedures for modifying or otherwise revising the Articles of Organization's smart contracts, adding dispute resolution as a possibility for what can be in the Articles of Organization, and then just renumbering paragraph 11 to paragraph 12. On page 7, under the operating agreements section in 1731-108, we have added language that the obligations, rights, and duties of the members to that can be provided for in the operating agreement. And new language on line 7 provides that an operating agreement may be a smart contract. And this was new from the last meeting, just to address and highlight that an operating agreement could be a smart contract, and to clarify that point. 1731-109, getting rid of some of the member managed distinctions, algorithmically managed distinctions. The new language there, providing that the management of a DAO is vested in its members, the members in any applicable smart contracts. So it's vested in the members or the members in any applicable smart contracts. All smart contracts utilized by a DAO shall be capable of being updated, modified, or otherwise upgraded. So it's providing some of those requirements there for a smart contract that's used to manage and what that needs to be able to do. On page 8, getting rid of member managed on line 5, getting rid of some cleanup there on line 8, getting rid of that divided. And then the or, just making clear that this is an or provision between paragraphs 1 and 2. And this is dealing with specifically the membership interests and voting requirements. And paragraph 2 would now provide that if all members have not contributed digital assets to an organization as a prerequisite to becoming a member, each member shall possess one membership interest and be entitled to one vote. And that's just providing kind of a default process there that certainly could be changed by a smart contract, articles of organization, or otherwise. On the bottom of page 8, section 1731-112, dealing with the rights of members and disassociated members to information. And this is primarily just kind of cleanup and grammatical corrections, just providing that to the extent the information is available on an open blockchain, members and disassociated members shall have no right to separately access records, et cetera, for the company. Under 1731-113, some cleanup there. At the bottom of page 9, again, kind of separating out the member managed, and getting rid of that language. On page 10, and here we're dealing with dissolution, and I would highlight, going back to page 9, section A, that this is a decentralized autonomous organization organized under this chapter shall be dissolved upon the occurrence of any of the following events. So what we're looking at for the rest of this page on 10 is the events that would qualify for dissolution. Paragraph 5, we see some changes. Originally, or in the existing statute, it's by order of the Secretary of State. This draft would change that to by order of a court of competent jurisdiction if the decentralized autonomous organization is deemed to no longer perform a lawful purpose or is no longer under the control of at least one natural person. Paragraph 6 provides that where all members of the decentralized autonomous organization have withdrawn. And subsection C, and here I'm going to actually highlight the staff comment. In the staff comment, there's a proposed alternative to subsection C. The way this was drafted last time, in that subsection C would give the Secretary of State the ability to investigate and dissolve the organization. There was discussion at the last meeting that the Secretary of State's office may not be the best place for that and to give that to the court. And so the staff comment actually provides some changes for the committee to consider that would accomplish that a little better than how it's currently drafted in the bill itself. And that would do that on page 11 by amending paragraph 5 that we see on the previous page, changing that to the decentralized autonomous organization no longer performs a lawful purpose or is no longer under the control of at least one natural person, and then giving in subsection C that any interested party may petition a court of competent jurisdiction for dissolution of a decentralized autonomous organization upon the occurrence of any of the events specified in subsection A. And some of those we'd seen previously of this section, and upon finding the occurrence of one or more of the events specified, the court shall enter an order dissolving the decentralized autonomous organization. So it creates a slightly different system that's what's existing, primarily allowing anybody to petition the court for that dissolution, alleging that it should be dissolved because of one of the events has occurred. And then the court would have the ability to take a look at that. And if it finds that there is that one of those events has occurred, that it would dissolve the decentralized autonomous organization. And it would take that out of the purview of the Secretary of State's office for this particular section. It repeals in section 2. And the what statutes that are repealed are listed there in the staff comment. Again, getting rid of quorum, getting rid of the definition of allow. The act is effective immediately on section 3 on page 12. And I stand for any questions on the bill.
Thank you, David. Any questions for David about the bill at this time? Yep, go ahead, Senator Cost.
Thank you, Mr. Chairman. I have a question that might show my naive approach to this, but I'll give it a shot. On page 7, when it says that all smart contracts utilized by a decentralized autonomous organization shall be capable of being updated, modified, or otherwise upgraded. Are there any sideboards on that, or is that just they can modify as they seem fit? I'm just wondering if that presents an opportunity for some that maybe is not approved by all the members or whatever.
David, thoughts on that?
Mr. Chairman, Senator Cost, I think that's a fair question. Generally speaking, I think my understanding of the way that process would play out is upgrading those smart contracts, I think would be something that's determined within the DAO already, whether or not that needs to go to a vote or whether or not that's something they want to set up to be automated, I think would be subject to how they've set up the DAO itself. So is it possible that it wouldn't need a vote? I think it could be. With the way this is drafted, is it possible that it would require a vote before upgrading or updating a smart contract? I think that could be the case as well.
Yeah, I think intentionally either way, and we can go to Mr. Kaufman. I was going to get his comments in a second, so maybe we'll yield to him in a moment to see if he interprets it otherwise. But if you think of it as an analog to the articles and other governing documents of an LLC and the processes that you would need to amend any of those, the expectation is that you would determine how those amendments would work and how the process would take place for the LLC in the governing documents, and then you would follow and adhere to those. I don't think anything here would change that expectation. So while it would potentially be an algorithmic change and potentially an amendment through smart contracts, so you're adding additional tools that could do it. But I believe the expectation for all of this language would be that would all be determined within the governing algorithms or documents that determine the outcomes for the DAO. Let's quickly get an answer from Mr. Kaufman and see if he concurs with that. And then Mr. Kaufman, after that, I wanted to go to you to add anything that we missed before opening back up to the committee for questions.
Thank you, Mr. Chairman. And with respect to that question on 1731-109, I think your answer was spot on, Mr. Chairman. The idea here isn't to give the participants or organizers of the DAO, carte blanche ability to modify these smart contracts without the input and without the participation of the DAO members. The contemplation here is that to the extent you're relying on some smart contract technology for the interaction between the members, that it can or is capable of being modified as needed, so that it's, in other words, it's keeping pace with whatever the DAO is being used for. So I think to your point, Mr. Chairman, that was intentionally drafted that way, so that one, we're creating an expectation that the smart contracts that might be governing the relationship between the members is capable of being modified. But again, we're not policing that. We're leaving it up to the members to determine that for themselves.
Thank you, Mr. Kaufman. And one thing I'll note on that is a lot of the language with regard to updating, modifying, or otherwise revising the organization's smart contracts. We made a lot of changes there based on the technical nature of the smart contracts, where the technology experts in the Dow working group suggested that the idea of editing it was right out, that you basically will create a pointer to an alternative smart contract as the way that you would end up implementing it. And we need to make sure that statute appropriately reflected the technology. So many of those changes are just to align our legalese with how the technology is actually implemented, so that we don't cause any challenges there. And with that, Mr. Kaufman, anything else that you want to emphasize on this bill draft? And I guess before I give the floor for that, I just want to thank the Dow working group that once again came together. We had tremendous engagement, quite a few Zoom meetings over the interim to continue to revise and refine and identify problems and challenges and listen to stakeholder input to lead to this bill draft. And Mr. Kaufman led those efforts during the interim to organize all of those changes and amendments to make sure that this bill draft was ready for the legislative session. So thank you, Mr. Kaufman, for your leadership on that. And anything else that we need to hear about in the bill draft that you want to emphasize based on the working group activities?
Thank you, Mr. Chairman. I would just make really a few high-level comments about the work of this committee and the subcommittee on the draft. It feels like over the last few meetings, we've gotten a little bit derailed and taken some steps backwards in terms of diving into a few of the nuances of the issues of this bill. And what I would say, and my observation has been in now using this statute for a while, we drafted, and I think people often forget that we drafted and approached this Dow Act as a subset and to work within the definitions that this legislature's already passed with respect to the open blockchain definition and the smart contract definition. And so I think one of my hesitations, and again, a lot of the testimony we've heard over the last several meetings has been incredibly helpful and very valid from a technology, let's keep it technology neutral, right? And let's look at other potential applications of the Dow going forward. I think, Mr. Chairman, my feelings on that right now are, again, we've created this entity to fit within our working definitional structure. I think the more we try to open it up and make it technology agnostic at this point, while I agree with that, I think that's a good thing to do, we need to look at that in a version 2.0. I think to try to do that in this version just is going to create more confusion. So with that, Mr. Chairman, I think we've come a long ways. I think a lot of the cleanups we've made are a step in the right direction. I think we're still going to continue to receive criticism from some of those that think it's not technology neutral enough. And again, I think those criticisms are fair, but I think we need to approach that with like I said, with a version 2.0 as this technology evolves and as we learn more about how the disputes in these types of entities unfold. But right now, I think we've come a long way from where we were, and we've cleaned this up really well. The only specific comment I would make, Mr. Chairman, is on that language that Mr. Hopkinson just pointed out regarding the dissolution. And of course, I would defer to the Secretary of State's office if they have any specific feedback, but I would urge the committee to consider the new proposed language that would make the petition process rest with the court. I think at least it's my understanding that rightfully so, the Secretary of State's office has some concerns about how that process might unfold and what their jurisdiction and authority would be in those contexts. So I would urge us to consider that new language and put that within the court, which is consistent with the underlying LLC Act as well, Mr. Chairman. So that's really the only specific comment. I think otherwise the draft is, at least from my perspective, ready to proceed, Mr. Chairman.
Great, thank you, Mr. Coppin. And I think it's a good point to note that the work of the Dow working group is ongoing, and that this is basically a feature freeze of things that were agreed upon as changes, but certainly were not the end of the list of things that the Dow working group was still considering. So the path will continue and more work is ahead, but all of the aspects of this legislation were agreed as improving the bill draft improving the statutes without breaking anything or causing any problems. So these were agreed upon and moved forward as this bill draft with more on the horizon. So committee, I'm going to go back to questions, see if you have any questions for Mr. Kaufman or David, but then I do want to go next to a discussion of pages 10 and 11, which is this C provision about dissolution, and talk that through to see where the committee wants to end up on that and maybe have a discussion with stakeholders there. So we'll do that next. But before we get there, any unrelated questions from the committee to Mr. Kaufman or Mr. Hopkinson? All right, seeing none, then let's focus on the page 10 and have a discussion. And I want to hear from the Secretary of State's office. And if we could bring up Deputy Wheeler once again. The heart of this, as indicated, was their previous draft, and even as drafted without the staff comment, the Secretary of State's office is involved in the dissolution process, and there's a process given for how that dissolution would be carried out and what parameters could potentially lead to the dissolution by the Secretary of State's office. But as drafted, you still would have the opportunity to work through a court of competent jurisdiction. In the alternative, in the staff comment, all of the action would be done through a court of competent jurisdiction, and the Secretary of State's office would not be queried or asked to dissolve by a third party one of these DAOs. So with that, Deputy Wheeler, could you provide us with your thoughts on the two alternatives that we have, either as drafted or with the staff comment? And welcome back.
Thank you, Mr. Chairman. I'd be happy to talk about this, and then after the committee finishes that conversation, I do have a couple other areas in the bill I'd like to address as well. But as far as this subsection, it really is our preference that this be put in the court system. First of all, this asks us to investigate. Statutorily, we don't have investigative authority anywhere but in our securities laws. And quite frankly, I don't have an investigator right now. So it's allowing us to do something I don't, number one, have authority to do, nor the manpower to do. Secondly, in our other statutory provisions throughout our other entity types, anytime we administratively dissolve or deny a reinstatement on an entity, there is the due process built in that it can then be appealed to the district court. So we would need those parameters built into this language as well to be consistent with the other entity types. But for the uniqueness of the DAO, it really, and in our internal conversations, we felt it really was better placed with the court.
Great. Quick question. So asking to have the other language built in, do you have language suggestions on how you would want that? To some degree, the existing DAO legislation is going to govern here, but this provides an opportunity then for dissolution through the courts, or would provide, if we use the alternative staff comment, that is rather unique to the features of DAOs. So did you have language that you suggest we incorporate into the staff comment alternative that we could consider?
Mr. Chairman, we really don't. And again, through great lengthy conversations within the office, we support the staff comment as it is drafted. And if there would be a court order dissolution, then our office would be notified, and we would then do our process on our end to dissolve the entity.
Okay, thank you, Deputy. Questions for Deputy Wheeler? Anyone online? Let's see. All right, seeing none. So clearly there's a great deal of support from your office, Deputy Wheeler, to use the staff comment language. Thank you. Any further discussion on this matter? Select committee, go ahead, Representative Western and then Representative Stith.
Thank you, Mr. Chairman. Just to refresh my memory, did this the subcommittee have any preference on this?
I think the subcommittee was fine with either process, I think it came back to us in the state, Secretary of State's office, and discussion of how we would do things in the state of Wyoming. And even we got into it a little bit in the last select committee meeting, that the process that we originally had through the Secretary of State's office didn't quite work. And that was the impetus more than from the working group thinking that as a policy, it would be inferior. As a policy, it seemed fine, but it just doesn't work with our system. Go ahead, Representative Stiff.
Mr. Chairman, yeah, I would support the comments of Ms. Wheeler. I think that we should take staff's suggestion and put the authority in the courts rather than the Secretary of State's office. I think it's more practical. I wanted to also ask the group how you would feel if we further amended it to, instead of saying court of competent jurisdiction, to say the Chancery Court. That would give the Chancery Court something to do, but also create its expertise, because if court of competent jurisdiction, you might wind up in any one of number of the district courts or circuit court for that matter. And those judges are already busy handling Title 25 and neglect cases and family law matters. It might make sense to give it to the Chancery Court.
Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. So we've had that conversation a couple of times. I've always supported exactly what Representative Stith is eyeing. I think it's a good opportunity for our Chancery Court and to give them something to do. The only thing that I haven't fully been able to work out on the policy side is, honestly, I don't think that the filing fee makes sense to dissolve a DAO. The filing fee makes sense to get in for a litigation matter in general. I wonder if we were to do this, I don't know how complicated we have to make it, but I would prefer some type of, special action. So it's got a different fee associated with it, because on the one end, on the other end, obviously, if it's a truly litigious matter and somebody wants to take that DAO into court, that filing fee might be the impediment of keeping out the not so good actors. So like I said, I haven't squared that in my head. I'd be curious on any other thoughts on the filing fee, but curious on Mr. Kaufman's thoughts as well. But I like the idea of trying to use our Chancery Court as much as we can.
And we'll go to Mr. Kaufman in a moment. My concern was what Co-Chairman Olson mentioned, which is, I think the right place for this is going to be the Chancery Court. I think getting to the point where that is where you would go and how you would want to do it is appropriate. But you do have a fee there, as well as you have the ability, under the way it's structured, to kick out of use of the Chancery Court and go back to whatever relevant court there is. So it creates an awkward policy tension that I don't think is the purpose of this legislation. It's the purpose of us working with the Chancery Court, I think, more and figuring out what its role is through the Judiciary Committee. And then the other idea of just access to courts, the idea that we have a high filing fee as the access to an individual petition for a request for dissolution doesn't seem acceptable. Now, if we eliminated that fee somehow, that would create some awkwardness also. So I don't know what the solution is. I agree with the intent of trying to get these things to be in the wheelhouse of the Chancery, but I'm concerned about selecting specifically the Chancery as the venue, particularly since we don't have a lot of activity in the Chancery yet. That might be something for the next build, where maybe we can think through how to amend in a Chancery preference. Mr. Kaufman, go ahead, and what are your thoughts and discussion on this?
Yeah, thank you, Mr. Chairman. And for everyone's benefit, I'll expose my bias right out of the gate. Of course, I love the idea of putting this in Chancery. I think there's a lot of benefits to that. To Chairman Olson's comment and concern about the filing fee, very understandable point for sure. The only pushback I would have on that is it's pretty commonplace now that when you see LLCs or corporations for that matter in litigation, whether it's over control or fiduciary claims, there's often a claim for dissolution attached to those complaints. And so I would hate to see us create sort of a backdoor into Chancery Court with a cheaper filing fee just by virtue of somebody tacking on a dissolution claim. I could see that happening. That being said, I completely understand the policy concerns of, do we want to have a high filing fee for the Chancery Court? On the flip side, you know, I'm a little of the mindset that we've created this alternative entity type, first of its kind anywhere, you know, and there is some clunkiness to it. We are going to need to establish some case law. There's also, I think, a policy argument to want to push that into the Chancery Court where it's a little faster and the process is faster. And yeah, that comes with a higher filing fee, but maybe that's the price of admission. I don't know. So just some thoughts there, Mr. Chairman.
Quick follow-up on that, Mr. Kaufman. Nothing would preclude someone from filing it as drafted in the Chancery Court if they wanted that expedited process. Is that accurate? As
Correct.
written, Court of Competent Jurisdiction. That
Correct, Mr. Chairman. My reading is that absolutely the Chancery Court could have jurisdiction over this. Of course, right now, and that's been a big reason that the forum selection discussion has been so important, is that for a defendant that just wants to delay, it's so easy just to file a jury demand or an objection, and then the case gets kicked out of that court. So by putting it in statute, you at least ensure that it remains in the Chancery Court if that's what we want. So, but understanding by definition, then you're removing someone's ability to have a jury decide that issue on dissolution, which I would argue is incredibly rare anyways. That almost never happens, but it is a fundamental right.
Yeah, good point. Representative Stith, go ahead.
Mr. Chairman, I think our discussion leads me to believe more strongly that it should be the Chancery Court, because dissolution actions are often used as a threat. And if you have them go to regular court, the process there is likely to take much longer, and it creates uncertainty for the continuation of the business. And so while you have this district court action, for example, pending, alleging a cause of action for dissolution, it's difficult for the company to make any useful business decisions or move forward. And I think the high filing fee keeps out the riffraff. I think you want people to be discouraged from dissolving it. People really should legitimately only want to dissolve companies, and will only do it when there's some significant amount of money at stake. So I don't think the filing fee really is the determinative factor here, but I don't think the chilling effect is substantial. And I think having it be Chancery Court sends the message to people who want to form DAOs that if there's some threat of dissolution, that it will get resolved quickly within 5 months, as opposed to 2 or 3 years in district court. So I guess I prefer the staff suggestion over the existing language. That is, I think we should definitely take it out of the Secretary of State's office. And my preference is to put it in Chancery Court. That's where I'm at on this.
Representative Stith, I mean, this gets back to one of the questions, though. Again, it's more about the Chancery Court than it is about this bill. Of you have the challenge of denial of access to courts or to the legal process by adding a high filing fee, which if you have an alternative, you're staying constitutional because you're giving expedited here, but you still have your access to courts here. And at the same time, you've got a statutory denial of access to a decision by a jury. And how can we, do you see a path where we can remedy and merge the idea that we really wanted in the Chancery Court, but we need to respect that backstop, which is why we don't have anything else. Nothing else statutorily is an automatic thou shalt be in the Chancery Court, because we have an obligation to protect those rights. Go ahead.
Yeah, Mr. Chairman. So I don't think the right to a jury trial is a problem here, because a dissolution action is by definition an equitable action, and there is no right to a jury trial for an equitable cause of action. So a jury wouldn't be deciding the dissolution question anyway. In other words, the Seventh Amendment to the US Constitution guarantees a right to a trial
Right.
by jury where there's more than $20 in dispute, right? That's constitutional right.
Mhm.
If there's money at stake, but where there's not money at stake and it's just an equitable issue of, does this thing exist? Does it not exist? Will you do this or will you not do that? Then you don't have the constitutional concerns of right to a trial by jury.
So I guess one of the challenges that I have is I don't want this to be the focus of the debate on this bill. I don't want to have to work the Chancery Court and constitutional rights and obligations surrounding the Chancery Court as the Dow bill, the Dow amendments bill, which is a cleanup bill, if that makes sense. I guess I'd have concern that this is a great way to kill a good bill by creating a firestorm around a nuance that isn't necessary.
Yeah, Mr. Co-Chairman,
Go ahead.
oh, wow. It's only when you're not. the
It
chairman.
knows who the chairman is. That's handy.
There, Mr. Co-Chairman, there really is something to that, and maybe less on your end of the chamber and more on our end of the chamber, but I mean, there's a clear competition for where any bill with the word chancery should go. I mean, why on earth does the Appropriations Committee have a bill that should be in my committee, Judiciary, on Chancery Court? And this is so there's a lot in there to unpack. And just by inserting the word Chancery Court, will we have a discussion about the Casper office building on the
Yes.
floor? Yes. And does it mean we can't defend it? I don't know, but I do think that's a valid point that the bill could go in a lot of different ways with that word existing in it. So some policy choices there to make. I definitely support Representative Stith, the staff amendment again, and I really do support it being in the Chancery Court. I do think there's some things with the fees to work out still, but I also do think there's a tactical question here too. But Mr. Chairman, go ahead. I'm curious to hear from Mr. Kaufman.
Yeah, Mr. Kaufman, go ahead.
Yeah, thank you, Mr. Chairman. And based on the co-chair's remarks here regarding the politics of the process, maybe I'll keep this shorter than I planned, because of course I'll defer to you on what's best to help this bill proceed. I just wanted to loop back on one thing that I forgot to mention, and forgive me, I don't have the exact numbers in front of me, but my recollection, we looked at this last time, was even the filing fees in the Delaware Chancery Court ranged from I want to say $300 on the low end, and there was even tiers based on the number of defendants, all the way up to $800 or $900. So again, I just wanted to reiterate the point that in my mind, I'm not sure that the $500 filing fee is necessarily the gatekeeper here or the focus, but I do again understand the comments of the co-chairs. The second thing I was going to say is I do wholeheartedly agree with Representative Stitt's comments that, again, the nature of this action being an equitable action, I think that's right. And I do think that we could determine the location of that particular type of claim for dissolution. To my comment and something Representative Stitt said about, again, attorneys and plaintiffs using a dissolution action as a threat, that happens all the time. But again, as I was sitting here thinking, that's probably something that the Chancery Court judges need to sort out as well and establish some precedent and law on as well, which might be another reason to put this in Chancery Court, that if you're going to file an action for a whole host of other claims and tack on one for dissolution, the Chancery Court judges are going to have to make a determination whether or not that's going to stay in their jurisdiction or whether that's reason or justification to kick it out. That might be a good thing, quite frankly, for us to develop some of that law. So those were my comments, Mr. Co-Chairs. But again, I very deferential to the two of you with respect to the politics of the process and understand those comments as well.
Thank you, Mr. Kaufman. Representative Stith, thoughts?
Mr. Chairman, we can go either way today. I just want to I think the important thing is to get this bill voted on, get it out of the committee, and then we can perhaps, if we need to further amend it on the House floor or the Senate floor, that's possible too.
Okay. And Representative Stith, on this, the point you bring up, I think, is a larger point also. This is just the Dow LLC portion of it. And if your thoughts about dissolution being something that should be expedited, then to me, that goes back to the larger question of maybe that is something that we should be trying to get into. And if it's an equitable action, and again, as you know, I'm not an attorney, so I certainly trust the two of you. I'm not. No, it's true. That trial by jury concept doesn't need to apply here. Maybe it is something where we can get a workload to the Chancery Court by having dissolution, rapid remedies, or something that goes through by default. Again, I'd probably still have concerns if the fees were substantially higher. That's something that I do spend a lot of time worrying about is access to courts. We already have problems with that. It helps if you have a lot of money. Your access to courts are currently a lot better if you have a lot of money. And if you don't have good access to courts. That really wasn't how courts were designed. They were theoretically supposed to be a system that was blind, right? That whole justice blind concept. We don't really have that, but it's good aspiration. So I think there's more work there. That is a larger scope and a separate scope from making sure that our DAOs work for the folks that are running DAOs. So additional thoughts on this point? Okay. And let's see. Mr. Kaufman, did you have anything else on this? I think the Secretary of State's office, I think Deputy Wheeler said that she had some other things to go into.
Mr. Chairman, the only final comment I'll make is again, a lot of the discussion we had last time, I think, was surrounding the concepts of baking in other flexibility in the DAO Act for things like, again, technology neutral, forward-looking use cases, digital identity, all that kind of stuff. I think, as I mentioned before, I think all of those considerations are totally valid and something we should be doing as we go forward down the road. I'm not convinced we're ready to address those concerns, in this draft and with these needed revisions. So I'm a little hesitant to dive too far into the weeds on some of those changes right now, but I do think we should going forward and continue to look at those. Thank you, Mr. Chairman.
Great, thank you so much. All right, let's go back to Deputy Wheeler. I think you said that you had a couple more comments on some of the language. So the floor is yours, Deputy Wheeler, on any concerns that you had.
Thank you, Mr. Chairman. I appreciate that. The first one that I have is on page 4, the new subsection C. That is a new subsection that was not in version 5 of the amendment bill that you discussed in December at your December 10th meeting. So as we're working through that new language, we do need guidance from your committee. So when Chapter 31 was enacted, it created a new subtype of the LLC. So our system, we modified it so that you could only use the word DAO in your name if you were a DAO LLC, according to Chapter 31. So now if it's going to be opened up that any LLC can be a DAO, we have to modify our system so that it's no longer locked down. And we are working on a fiscal impact with the significant budget cuts we took. I have to see if we even have any money to undo all that. But then where it gets a little bit more tricky for us, if this is opened up to allow any LLC to act as a DAO without forming under Chapter 31, then will they still be required to do a public identifier and have certain statutory requirements in their articles of organization that are required in Chapter 31? If so, we then need to further modify our system so that if you're a regular LLC and you have DAO in your name, you must now also provide this information. So we are looking for guidance from your committee as to which direction you want to go on this particular section.
Thank you, Deputy Wheeler. Mr. Kaufman, I'll go to you for a response.
Yeah, thank you, Mr. Chairman. And referring everyone back to last meeting, I was one of those folks that I'm still not convinced that this language is necessary. I tend to agree with the Secretary of State's office that it might create some confusion. I understand, again, last time that the discussion was, hey, why can't we form an entity utilizing some of these technological aspects as a regular LLC? We don't have to just do this as a DAO. And I think we as a committee agreed with that maybe we need some clarification. I'm not sure, Mr. Chairman, that needs to be said explicitly or not, because we know people are doing that now. And as we talked about last time, what the Dow LLC Act does is create a set of uniform rules with some policy considerations about, more public disclosure and things like that. If an entity wants to rely on technological aspects and not conform with the Dow Act and be an LLC, I don't think there's anything stopping them anyways. So, Mr. Chairman, that's maybe not a very good response, but I guess what I'm saying is I think either we take it out and leave it as is, or to the Secretary of State's point, we make it clear that, yeah, this is a business decision ultimately for these entities as to how they want to file.
Thank you, Mr. Kaufman. Committee questions for either Deputy Wheeler or Mr. Kaufman? So the discussion on the working group with regard to this concept was that there were some that did believe they either had to file as a DAO if they wanted to do anything DAO-like in Wyoming because this came into existence, and that entity didn't want to follow all of what we had and ended up filing in a different state on the East Coast because it was unclear to them whether they could simply file as an LLC with DAO-like characteristics or adhere to our DAO statute. So the reason for this, or the intent of this, is to provide clarity that you could engage in algorithmic management in the same way that you could in Delaware or Nevada or someplace that doesn't have an explicit DAO statute that provides additional provisions, but you would get none of the benefits or anything else that you would get from the new language and the new DAO supplement. That's the intent, is to basically say, just because you've got something that's a DAO doesn't mean you have to use the DAO LLC in Wyoming. We're not trying to restrict, we're trying to provide a feature set. And if you look at our LLC Act and think that it's better than our DAO LLC Act for what you want to do, then choose the LLC Act, the old school LLC Act. That's the intent of this language. And that was based on some concerns that were raised where the ambiguity was causing some to think that you couldn't do it, others thought you could, and we thought we would just be clear. Now I understand the Deputy Wheeler's concerns where they've set themselves up where if DAO is in the name, you need to be a DAO. So any thoughts? I mean, and again, Mr. Kaufman's right, we can strike C. Go ahead, Representative Smith.
Mr. Chairman, and I'd be happy to take comments from anyone in the room who knows. But I thought that one of the basic trade-offs here was that we were requiring a bit more transparency in the DAO legislation because there's no home office to call. That is, you can't pick up the phone and call a human being and say what's going on. If I'm a member, that it's all just automatic and autonomous and depersonalized essentially. And so for that reason, we have this public identifier requirement. We have the idea that you can go to the blockchain and verify what's happened in the organization, that there's sort of this transparency that happens under the DAO Act. If you can do all of the same things with the regular Limited Liability Company Act, then my question is, wouldn't I, as an organizer of one of these organizations, wouldn't I just always prefer to use the traditional limited liability company, because then I don't have to be transparent and I can, run a scam if I want to. I mean, I think there may be some virtue to say, if you're going to be an autonomous organization, we're going to require a little bit more transparency, which I think is the purpose of the public identifier and the blockchain feature of the smart contracts. But maybe I'm misunderstanding the whole purpose of why we have this. So if we put this in, then might it turn out that no one will use this statute because they don't want to?
I think the easy answer there is you look around the country and all of the rest of the states don't have a DAO LLC. We do. All of the other states have LLC acts that are relatively similar to ours. Some DAOs file in those states, And some DAOs are excited about filing in ours because we're formally recognizing it. We're providing, I think, legal and legislative clarity, and we're going to have a chancery court that understands how to deal with it. We've got a good feature set. So obviously, this is a place where forum shopping is a key and common approach. Which laws do I want to adhere to, and I'll go there. I don't know how many companies are really out there that are looking at Wyoming and saying, boy, I'd sure like to operate my DAO in Wyoming, but I don't want to use the DAO LLC supplement. I want to use the old school LLC. But to the extent that the focus has been on flexibility and feature set and not just adding additional restrictions. If someone is seeing it as an additional restriction where we're creating something new that holds back DAOs so that they're going to look to other states because Wyoming is now the most restrictive DAO state, that wasn't the intent. So I think our intent is to enable, not restrict. And we drafted the legislation with that in mind. And now we're hearing anecdotally that maybe we're restricting. This is intended to address that so that if somebody sees us as restricting and they just liked our old LLC better, they liked it better last year than this year. I don't know. Do we have, and it's a good point, do we have an interest in holding them to the new DAO LLC? Or are we comfortable saying, hey, if you think the old act was good enough and you want to operate under that, by all means do it. But we still think this new one's better. And we can go either way. Again, as Mr. Kaufman said, totally a policy decision. And I don't think it's probably happening a lot, really. I'd be surprised if it were, but we definitely heard the concern raised. And so we're trying to address it. Other thoughts? And Mr. Kaufman, anything you want to add to that? Is that a fair characterization?
Yeah, thank you, Mr. Chairman. And sorry, I keep dominating the conversation here, but I agree with your comments, Mr. Chairman. The one thing I would add, though, is there is no doubt we are seeing DAOs form all over the country using various state LLC acts. What I would stress, though, and we've talked about this on this committee, the distinction that we've created in Wyoming is a separate category for these DAO LLCs with its own set of default rules, which you are right, no other state has. So that's really what we've provided here. And that's what I mean when I say it's a business decision for these entities, in the same way that it's a business decision for entities to decide if they want to be a corporation or an LLC or a partnership, right? They have to go through that analysis and decide what entity set and what uniform set of default rules is the best for them. And so I think you're right, Mr. Chairman. We've given them a menu of options. We've given them an alternative of DAO LLC. I don't think it's up to us necessarily to always remind everyone, oh, you can opt not to do this, because I agree with Representative Stith's comments that, right, part of the policy consideration here is if you're going to be a DAO, you're going to have this subset of rules. We're going to require a little bit more of you, and this is what we've asked to see. You don't have to do that, but that's a business decision, and how the courts might treat you under a traditional LLC structure if there's a dispute is something that's going to have to be sorted out, just like it is with the DAO LLC Act. So again, I come back to, I do think it's a policy decision, but I don't think it's necessarily the right policy decision to constantly remind people of the options, because they're already using those options. Thanks, Mr. Chairman.
Thank you, Mr. Kaufman. So on this point, I think there are a few approaches. One, we strike C, and it probably does the same thing unless somebody believes it doesn't, and then they go somewhere else. Another alternative to address the Secretary of State's office consideration is simply say, subject to the naming convention, so that the Secretary of State gets to maintain that if you call yourself a DAO, right now that is a DAO LLC, you're just going to have to call yourself something different. And then I think that probably meets all of Secretary of State's interests at that point. And they treat them like a traditional LLC entirely. They don't have any of these provisions in effect, but they don't get to call themselves a DAO in Wyoming. And that might be an easy way to do it. And then the third option would be leave it the way it is now, although I think I see where that causes some confusion for the Secretary of State's office where they want some bright line clarity. I think the third option is probably a bad one, but the first two are fine. Anyone have any thoughts on a preference there of an approach? Mr. Co-Chairman, go ahead. Oh, fine.
Yeah, Mr. Co-Chairman, I'm comfortable just deleting it. I feel really comfortable. This isn't an area, I'm not an expert in this area of law, but I feel really comfortable that it's not necessary to accomplish that goal. I think deleting it, you can still, it's a supplement. This is a supplement. So you can still use wherever the Title 17 does not conflict with this supplement, you can use those provisions of law. And that's true of all supplements in the LLC Act. So I think if somebody really wanted to do that, and they could, and it would be, if it were less restrictive for them for their model, that's great. I think if they've made a business decision to go somewhere else, there's so many other factors that go into, making that decision to form here and not form here. And to Mr. Kaufman's point, if people are forming DAOs all over the country under traditional LLC law, then their choice to come to Wyoming is because of what we've laid out in the statute. So I think that's really what we're trying to accomplish anyway. And I just think there's no real way to know that individual that went to the other side of the country didn't do it for whatever reason, filing fee, who knows? Their lawyer lives in Delaware. I don't know. So, that's where I'm at, Mr. Chairman. I think it does cause confusion. I think it also confuses the body of the chambers unnecessarily. Because we addressed this issue with the DAO legislation in the beginning. We told them it was a supplement. It is a supplement.
I think they're frozen.
Anyone else? Let's see, Representative Yen, I didn't see your hand.
Oh,
Go ahead.
sorry, Mr. Chairman, your screen was frozen for a little bit there when the chairman was talking.
I'm sure it was very eloquent. He said rather insightful things, and I think he pretty much took us home. So Representative Yen, he was suggesting that the way our LLC Act is currently structured with supplements certainly gives the clear direction that you don't need to use the supplement if you choose not to. So that should probably suffice in providing effective guidance, and that the C provision would therefore be unnecessary, and we might be able to strike that. All right. Any further comments, questions from committee members? Deputy Wheeler, back to you for a second. I don't know if you have anything else to add on this topic, anything else to add? It sounds like you'd be perfectly comfortable with C being struck. That seems to take care of your concerns. And I can't hear you, Deputy Wheeler. Can you hear us? Still not getting you.
Mr. Chairman, can you hear us now?
Yes, we've got you now. Thank you.
Thank you, Mr. Chairman. We would certainly be fine if subsection C was deleted. That would provide that bright line for us. Thank you.
Yep. Deputy, did you have anything else, or was that the conclusion of your concerns?
Mr. Chairman, I do have one more area, and then I will be done.
Oh, please do. Yep, go ahead.
So, Mr. Chairman, the new language starting on the bottom of page 5, line 20 through page 6, line 5, regarding the public identifier. First of all, I just want to say thank you. That language will be very, very helpful to our office as what we have encountered is 2 things. Number one, we have had filers who just don't want to provide a public identifier. They don't know what one is, and we have gotten several pretty nasty emails from people because they want us to tell them what their public identifier should be, which obviously we can't. And then we have those who are just beginning the structure of forming their DAO and getting their ducks in a row, and then they'll have their public identifier. So we have allowed those to file an amendment when they get their public identifier, but we don't have a duration on it. So this is very, very helpful for us to have that 30-day duration. The only change that I would request is on line 3 of page 6, the word reject. Statutorily, we must reject a filing within 15 days. If this word could be changed to administratively dissolve, that would be very helpful on our end, sir. And then that is all I have, Mr. Chairman.
Thank you, Deputy Wheeler. Any questions on that concern for Deputy Wheeler? Makes sense. And I'll quickly, while we're on that topic, Mr. Kaufman, any concerns there? It seems perfectly legitimate.
No concerns, Mr. Chairman. Thank you.
David, what are your thoughts? Go ahead.
Thank you, Mr. Chairman. I'm just wondering, do we need to tweak the shall be deemed to have not been formed language if we're changing it just to be administratively dissolved, or is that still okay? And I guess
No.
ask Mr. Kaufman his thoughts on that.
Interesting. Yeah, I see the point there. Deputy Wheeler, what are your thoughts? I'll come right back to you.
Thank you, Mr. Chairman. I think that is a great point, and we do agree with that.
That we would have to tweak it, Deputy?
I'm sorry, Mr. Chairman, yes, to remove that language.
Okay. Representative Stiff, thoughts?
Mr. Chairman, I agree with Ms. Wheeler that what you would want to say is that the organization shall be deemed to be administratively dissolved, period, because there's already good law and the statutory framework for what happens when you administratively dissolved.
Understood. Mr. Kaufman?
Mr. Chairman, I completely agree with those comments.
All right. Does anyone on my team of attorneys disagree in any way? Okay, excellent. We've got a legion of them here. Where's Senator Nethercott? She's not here right now. She must be in her meetings. All right, good. When all the attorneys agree, everything's fine. So we'll remember that one. All right, Deputy Wheeler, anything else?
Mr. Chairman, no, that is all we have. Thank you very much.
Thank you. Appreciate your participation today. Okay. I think we are done with our testimony from executive and elsewhere. So I think we're on to public testimony now. And I know we've got at least 2 available. Daza, are you out there? Let's bring Daza in if he's out there. Okay, let's bring in Brendan and Dane. There's Brendan. Brendan, the floor is yours. Welcome. Good morning. And again, thank you for all of your help, support, and participation on the DAO working group and the digital identity and all of the other work we've been up to. Please introduce yourself and the floor is yours. We cannot hear you. Still cannot hear you.
Once again, thank you, Chairman.
Hey, we got you this time. There we go.
Great. So first off, I'll say I'm glad to see that the DAOs have successfully broken the statutes in Wyoming. I think that was the intent. Right? So my name is Brendan Marr. I'm an MIT Media Laboratory alumnus, as you all know, and I'm on the working groups for the DAO working group and the digital identity and data privacy working groups. I'd like to speak to 3 areas succinctly and briefly. The first is on public identifiers, the Court of Chancery, and version 2.0. First, regarding public identifiers, there is some clarity I can give in terms of public identifiers, and this gets to the heart of digital identity and naming and all the other things we've been talking about in terms of smart contracts and wallet addresses and naming of series LLCs. All of these things are related. So a public identifier, as many people in the community, in the technology community, and people who are forming DAOs are looking to have a representation of, are a pointer to a 0x address, or a modified version of that. So not necessarily a signature. To the point, we're not going to solve this here, but it is something that we will need to go forward and resolve, how these things relate to the registered agents, et cetera, et cetera. So there's much more work to be done here. Item 2 would be, I concur with Representative Stiff on the Court of Chancery. I think putting the resolving power of many of these issues in the Court of Chancery will be extraordinarily important, because if these matters are booted to other courts, you're going to have the question of how will other courts have the knowledge and ability to resolve smart contracts, or these addresses, these contracts and names that are signed, cryptographically signed, as these 0x addresses, et cetera, et cetera. So expertise will be needed in order to resolve these issues. And now that we have these DAOs and these things are put into play, they're going to come up, and we're going to need a court which can understand even what these things are. Item number 3, and this goes to Mr. Kaufman's version 2.0, and Senator Rothfuss's idea of more work ahead. I should just put out there as a footnote that a small little jurisdiction to your south called Colorado has the limited liability cooperative associations, which many people are looking towards using as a forum for DAO. So there's going to be other types of nuances and entity forms, and permutations that DAOs will potentially take on. And these are some of the other areas that we will need to look towards in order to maintain that Wyoming is competitive. And that is all I have to say. I'll take questions on any of these matters.
Thank you, Brendan. Any questions for Mr. Maher? Go ahead, Representative Western.
Thank you, Mr. Chairman. Mr. Mars, so it sounds like you believe that this whole concern around public identifier is not going to get solved today. I'll take your word for it on that. But maybe just humor me a little bit and say, any idea on what would be a sufficient definition of what that would mean?
Mr. Maher, thoughts?
Yes, certainly. I do believe, and this goes to the broader issues that we will need to resolve in terms of digital identity, because at the end of the day, what we are really talking about is digital identity and signing. So we have under statutes is legally already from 30 years ago or so, 20 plus years ago, UITA, which Mr. Greenwood had worked on as the Uniform Electronics Transaction Act, which provides the uniform law for signing of electronic transactions through cryptographic means. The problem is that, when you bring any of these ideas into any lawyer's office, they're going to say cryptographic what, right? So they don't understand, the nature of these signatures. But it's all in the law. It's all legal. We can do these things. Just people just don't understand how to use them. The reality is right now, these things are actually in use right now, because this is how transactions on the blockchain are signed. So, there's some clarity we need to put in language, which gives kind of some guidance in the fact that names and signatures, names of companies, signatures of those who are authorized to sign as well. Addresses of wallets. These are actually all the same thing, because when they're represented as a 0x address, they have a form of any of these things. And you can also think of them as an IP address. So I don't want to go too far off the handle there, but to answer your question, some clarity on the fact that we can use signatures, and just to be clear, there's some nuance here, permutations of them, because we have to deal with, as Mr. Allen has stated in the past, the issues that, keys can be updated and rotated. But once we work through that, we will have a means for people to sign things cryptographically and have a representation of names which can be embedded in the blockchain. And these things will resolve all these issues. I hope that is helpful.
I think Representative Western probably totally has it now. Representative Western, follow up.
Thank you, Mr. Chairman. And I do, as a matter of fact. My follow up. So it kind of sounds like, on a broad sense, that a cryptographic signature on a recorded blockchain could potentially be sufficient for a public identifier, pending further discussion and dialogue.
So
yes,
go ahead,
with
Mr. Maher.
sure. Just with the caveat, just to bear in mind that it's not a one-to-one mapping, because you have to account for the fact that keys get rotated and things like that. So just bear that in mind. It's important to note that you're actually not, the representation is not exactly the key. Just for clarity on that, but we want to be able to do these things. Yes.
In the working group, we threw this question out so we could have a bright line, obvious clarification of what an identifier was. And we had a good discussion, and there was no easy way to come up with a consensus bright line based on like a global standard right now, nothing easy to point to, which was the struggle that we had. Even though these concepts, I think, are well understood, particularly if we're talking about a blockchain, then there was concern about, well, what if this smart contract isn't on a blockchain? Blockchain isn't the only technology. So we raced around for a little while, but we just couldn't come up with anything that was very clearly, well, this should certainly be it. So again, some guidance was given to the Secretary of State's office on these are what identifiers would look like. And as Mr. Maher has pointed out, pointing to a location on a blockchain, and there are addresses like TCP/IP addresses that point to where you're at on a blockchain. That is, this is us. This is our nexus, which might include the articles of organization or a pointer back to articles of organization, but something that you can point to, hang your hat on. And then, as Mr. Maher has pointed out, you can cryptographically sign, which we don't necessarily have the capability of, but we sure want, authoritatively, to show that you have ownership of that. You can demonstrate this is mine authoritatively. Nobody else in the universe, if they don't know the answer to what is my key, could authoritatively point to it and claim ownership of it, which is the beauty of the private key structure and this whole cryptography. So there are a lot of concepts. Folks like Brendan know what they mean and what they would like to see and what is and isn't. But coming up with something that was a clear, bright line, 15 words, this is what we're talking about for a unique identifier that a DAO would use, was not quite ready yet for prime time. So I'm hopeful, again, in like a 2.0, as we move forward, we really need that. And we could do it through rule and regulation also. That's very viable. And we need to work on this and better define it. But folks that are setting up DAOs, honestly, and are expert in the field, know what to give. They do. And it's almost a good test. If you don't know what you're giving for your digital, for your unique identifier when it's requested, you probably don't have your DAO set up yet.
So
go ahead.
Mr. Chairman, I take it that the idea is that someday in the future, we will define what a public identifier really is. but we're not going to do it today. Is that what you're saying?
Yes, that's what we're saying. Exactly. This is not the bill that comes up with the perfect definition of the public identifier at this time. And again, the Secretary of State's office has the authority to go in and through rule and regulation and help define that and build moving forward if they want to. And they've been working with technology experts with the working group that have weighed in and given them advice and helped to define this a little bit better. But again, we don't have, I don't think we've got a bright line definition quite agreed upon by the folks that are those technology experts well enough that we can create the statute for it. And I hope we have that relatively soon, and we'll keep working on it, honestly. Brendan, you wanted to weigh in a little bit there?
Yes, I think those in the know can supply public identifiers. The question is, will you accept them?
Yeah,
I think
fair.
the problem is it's not clear to those in the community that, you know, if we give you, you know, an address, a blockchain address, or you know, a cryptographically signed you know, a signature. I mean, there's more pieces to this. You know, you have to have systems that you know will accept this, right? And ideally, and this actually really gets to the really cool, interesting, wonderful part of all this, right? Is that, you know, once we actually like work through a couple of these details and work through, and by this I mean registered agents, right? Because ideally, if we get all this right in statute, so that you build out registered agents that are competent in this, then they will be able to take in these addresses, but also there's more to it than just an address that, you know, where you sign, it's just one thing. It's just a bunch of scribble on a text, right? But, you know, cryptographic signatures, you know, they're not just scribble on a page. They're these numbers, but there's more pieces to it, right? There's the signature itself. In order to be useful, is actually more than one part. It's the signature, which is with a bunch of numbers, and then in order to make sense of it, there has to be a place for the original message, and there also has to be a key. So there's really three parts. The problem is the challenge is that you have a system where you're only allowing for one of these three pieces to be submitted. And therein lies the problem. This is why, you know, people can't come to Wyoming as a jurisdiction, because you only have one of the three pieces that are useful for signing. So really you can't sign anything. So nobody's going to come. I hope that is providing some clarity.
Thank you, Mr. Marr. Any further questions? All right. Seeing none, thank you, Mr. Marr, once again. And up next, we've got Mr. Lund. Mr. Lund, welcome.
Thank you very much.
Please introduce yourself to the committee, and the floor is yours.
Certainly. So Chairman Rothfuss, Chairman Olson, and honorable members of the select committee, my name is Dane Lund. I am a core contributor of Alliance DAO, a DAO that's established to provide builders of the infrastructure and content of the next generation of the internet, often known as Web3, with a platform and network that encourages and rewards the pursuit of creation and creativity in blockchain technology. As a side note, we see an increasing number of DAOs that are, or pre-DAOs that are coming through our program. And so we have an interest in fostering strong legislation and regulation in the DAO space. I'm also a member of Global DCA, which is a self-regulatory organization focused on digital assets worldwide. And I'm also a resident of the state of Illinois, where a growing group of lawyers and policymakers are taking note of what's going on in Wyoming, and we are advocating for Illinois to acknowledge DAOs also. So for that, I'm grateful to the state of Wyoming for taking the momentous step in recognizing DAOs. Wyoming has a history of leading the nation as the first state to recognize the LLC in 1977, 14 years ahead of the state of Delaware. So your pioneering efforts in corporate structure give credence to the concept of federalism, where a single courageous state may, if its citizens choose, serve as a laboratory and try novel social and economic experiments as articulated by Justice Brandeis. So acknowledging that there have been many comments today, I really want to focus on one proposed addition that should work in chorus with the amendments proposed today. Just to keep it brief, the amendment would be to 1731-113, and it would create default rules for entry or withdrawal of members. The bulk of the amendment, as provided in the statement, is that there would be a section B or a subsection B, and I'll read it for you, where the articles of organization, operating agreement, and smart contracts for a decentralized autonomous organization are silent on the manner by which a person becomes a member of or withdraws membership from the decentralized autonomous organization. A person shall be considered a member if and when such person purchases or otherwise assumes a right of ownership of a membership interest or other property that confers upon such person a voting or economic right within the decentralized autonomous organization, and such person shall cease to be a member if and when such person transfers, sells, or alienates all such membership interests or other property that confers upon such person a voting or economic right within the decentralized autonomous organization and retains no further right of ownership thereto. I won't read it again, so to spare your time. The current statute enables DAOs to define both the relations among the members as well as what it means for withdrawal of membership in the Articles of Incorporation. And there's a rule of deference to the operating agreement or the DAO's smart contracts. There's a modest disconnect between the form and function as written in the current statute. Many DAOs do not clarify in their documentation what constitutes membership. Instead, these DAOs are structured such that a right attaches to a token or other form of smart contract enabled interest and not to a specific person. In this way, a token right is analogous to the real property concept of a covenant that runs with the land and stands in contrast to a personal covenant. Absent wallet-specific transfer or access restrictions written into the DAO's smart contracts, a DAO's smart contracts interpret the token or other such unit of governance or economic right as the member, and they're agnostic to which actor holds the wallet to sign a command. For this reason, DAO's documentation often omits reference to the acquisition of or withdrawal of membership and simply defines the rights that attach to the relevant unit of value within the DAO. DAOs are likely to overlook providing explicit rules for the creation or termination of a membership relation and may be unable to do so sufficiently within the statutory framework that exists now. The working draft provided with this meeting included a helpful clarification to membership interest, which states that it may be ascertainable from a blockchain on which an organization relies. The proposed amendment in my statement, along with the working draft amendment, function well to help identify the beginning and end of membership. Smart contracts enable a broader scope of actions that can be performed on tokens that may apply than those that may apply to traditional LLCs. For instance, DAOs may permit actions such as staking, whereby token holders commit to lock their tokens to become a network validator or to delegate their tokens to a network validator. In some cases, token holders who stake their tokens lose governance rights for the period during which the tokens are staked. However, they have the right to unstake the tokens, either at will or at a specified time, and thus retain ownership. In such circumstances, statutory interpretation can lead to differential outcomes if there is not a default rule for delineating the start and end of membership. The proposed amendment to 1731-113 provides a clarification by setting the beginning and ending of the ownership of economic and voting rights as the beginning and ending of membership. Thank you for your time. I tried to read that as quickly as I could. And thank you for breaking ground on innovation in digital assets. I'm happy to answer any of the questions you might have.
Thank you, Mr. Lund. I appreciate it. And we do have, and for the public out there, the statement is on the website's list of materials. So that's available. We've got Mr. Lund's statement, which includes the suggested amendment language. And candidly, Mr. Lund will probably not adopt something like that today, but we'll definitely take it into the working group and we'll review it and we'll figure out how it fits, work with the staff and see if we can potentially take action on it for this legislative session or put it into our 2.0 build. But I definitely see the point that you're getting at, trying to provide kind of clarity on moving in and moving out of the DAO membership seamlessly by default rule. That makes good sense. With that, let's go to the committee to see if there are any questions. Go ahead, Representative Stiff.
Mr. Chairman, for Mr. Lund, thank you. Your proposed amendment seems very interesting because it seems like it creates more fluidity for getting in and out of a DAO. Mr. Lund, do you see any negative consequences or downsides of adopting your amendment? I mean, are there any potential pitfalls that you can identify?
Mr. Lund, go ahead.
Sure, Representative Sith, thank you for the question. I suppose if I were to put my plaintiff's lawyer's hat on, I would want to, know the membership, at any given point, supposing there were some violation committed by a DAO and we needed to know the membership. So there is some risk that there is difficulty in getting a snapshot of the membership, either named or by wallet. But that should be resolvable by, blockchain analytics. Chain analysis should permit, a time frame snapshot of who is a member. So if there's a need to know the members, assuming that they're not anonymized, that should be possible. It just may require additional analytics on behalf of that person or entity trying to identify the membership.
Follow-up, go ahead.
No, Mr. Chairman, thank you very much. I like this amendment and I think it kind of potentially plugs a gap into the current statute.
Thank you, Representative Stiff. Mr. Kaufman, have you had a chance to review this?
Thank you, Mr. Chairman. And yes, I have. And I echo the sentiments. Honestly, I think it's a very, very interesting solution. I mean, practically, this is what a lot of the entity DAOs that are forming now that are taking the time to put together operating agreement and rule frameworks are doing, is taking the effort to, at least the ones that I've been exposed to and working with, are taking the time and effort to try to define and distinguish between what that token you might hold or whatever digital asset you hold represents in terms of voting rights, economic rights, et cetera. So I don't at all disagree with the notion that creating a default rule could help. I think, and I would be curious to get Mr. Lund's comments on this as well. I don't think the current statutory framework keeps in any way, shape, or form entities from doing this today. And like I mentioned, Mr. Chairman, I think a lot of the entities are trying to figure out ways to define what those default rules are. But I would be curious for Mr. Lund's just comments with respect to, as far as the existing rules go now, is there risk in over defining what those token holders' rights might have in the event that, for example, we're seeing governance DAOs pop up where we want to make it clearly distinguishable that there's no economic rights that attach to that token? Do we accidentally create arguments, for additional rights in the default rules where the DAOs want to separate those rights and the token holder? So I would just pose that question, but generally speaking, I'm very supportive of this concept.
So thank you very much.
Mr. Lund, go ahead and respond.
Thank you very much for the question. I would say that the idea is to help those DAOs that may not be able to reference their own blockchain and really translate what's going on their chain to what is membership. But those DAOs that have that problem that also want to utilize the DAO statute are best served by having some bright line rule for knowing who is a member and who is not legally. And so the problem that you've identified is that there are divisible rights within tokens. And so now there are governance DAOs, there are social DAOs, there are protocol DAOs. Generally, the tokens within the community have at least one of two rights, which is economic and or governance, usually both. But those can be divided based on the facts and circumstances of how the DAO operates. And so having the bright line that says you are a member if you own, not borrow, not are affiliated with, but own the right to governance or economics, and you are no longer a member and you pass out of the membership if you fully dispense of your ownership. I think that's very helpful. I don't think that it conflicts with some of the other purpose of the statute. I do think that it helps clarify, and I think there's some sense that membership interest is very hard to define here. And so as to the timing, that the membership at any given time, it's very helpful to clarify.
Thank you. Follow up, Mr. Kaufman?
No, Mr. Chairman, and forgive me, I did review the language, but I'm having a hard time finding the language as I sit here right now. But one more question, and maybe anybody could answer this. The language does qualify this potential amendment that unless otherwise, right, specified by operating agreement, smart contract, et cetera.
It does. It's default, just like the other language we use, correct?
Yeah, with that, Mr. Chairman, again, I'm very supportive of this language.
Thank you. Further questions, committee, for Mr. Lund or discussion? All right. On this one, when we work it, I think there's a couple of possibilities. One is that we could tentatively adopt it and then try to wordsmith it more and make sure, we've got suches in it, so it doesn't fully comply with kind of our legalese. But the concept is, I think, clearly consistent with, as Mr. Kaufman noted, what we expect the default to be. It's definitely a fair set of defaults for how a DAO would and should probably operate in the absence of further parameters. I think it well characterizes that. We can also leave it for later, work on it between now and the session, or we could push it down the road further and work on it in the next interim. Any of those are options, I think, to consider. Representative Stith, it sounds like you're inclined to get it done. Yeah.
Yeah.
Mr. Co-Chairman, what are your thoughts?
Mr. Co-Chairman, I trust in Representative Stith and Mr. Kaufman. Sorry, Mr. Kaufman's. I had to make sure that was true. I'm just kidding, Representative Stith. I trust in their analysis. I think, to your point, we can pass it as amended, but really conceptual in that we want David to go back and conform it and clean it up as we would see it inside of our statutory construction.
Yep.
I think that's easy to do.
That's pretty easy. Yeah, I don't think there's not much there that probably would need to be tweaked. Yep, go ahead, Senator Costa.
Thank you, Chairman. My thought was looking more towards legislature, and if you have a large amendment coming in, sometimes it has a tendency to turn people off towards it. So I think the better this is fitting in now, the better chance we have of it passing in the future.
Any concerns with that? Anyone online? Representative Yin, are you comfortable with this language in general? Okay. Yeah, and again, it's a default position, just to be clear. If you don't like these terms as your default, you just change them. So there's no real danger in over prescribing. Okay, any further discussion on that? Mr. Lund, thank you so much for bringing this to us and for your testimony, support, and discussion. And we hope Illinois comes along eventually and just copies and pastes ours like everyone else should.
Thank you very much for your time.
Thank you. All right. Do we have any more online public testimonies? Anyone else out there? Do we find Daza? No. Okay. Any public testimony in the room? Come on up. Welcome once again, even though we know you, please state your name and tell us your thoughts.
Name is John Stokes, representing WyoSky Dow LLC, which is the economic engine for the space industry for Wyoming. I guess I'd just like to kind of give a testimony, a story, and maybe can what we're doing, and maybe could give some clarity and outline some definitions, I guess specific to the public identity and the membership, withdrawal, and fluidity of the organization. So part of our fundraising and membership identity strategy, we're essentially doing an NFT membership program. So how many of you guys know what an NFT is, or what non-fungible, or difference between that and fungible is? I guess I could give a good example. Everybody knows post stamps or postage stamps. So like old postage stamps that are collected, you could kind of think of that as like the non-fungibility and the difference in like how one stamp in a collection might be a different grade or different value than the other stamp. So that kind of like kind of stumbling upon my words, but like the difference between like postage stamp collecting and then the postages that are issued now, where you could buy any stamp for $1 and redeem that stamp and use it for its intended purpose. So I guess that could kind of explain the difference between non-fungibility and fungibility. With that kind of like base understanding, we could kind of go deeper into how we're using these postage stamps, these non-fungible unique postage stamps, to represent the identity of the individuals in our organization, right? So through this NFT membership tiered structure, we have different ranks, kind of like, the Star Trek fleet. We have the cadet, ensign, lieutenant, captain, and each of those ranks kind of offer different access to the organization. From the base layer, everybody in the world is entitled to operate with the DAO, decentralized autonomous organization. So with that context in mind, you can't really restrict members, but with the context of our ranking system, when membership is transferred from one individual to another, I guess there is that context of removing membership roles within the organization. And then we would need some like clarity for protections within that for people that didn't intend to transfer, sell membership, and they were hacked, for example. So there should be some kind of like legal framework arbitrage layer that can allow members that were in that position to remain members, and maybe the DAO could burn or whatever, nullify that address and reissue a membership token, if that makes sense. So that's kind of addressing our membership and identifier roles. Another role of our organization is we kind of like to see fluidity across industry, state, and through the university system. So we have an office at the WTBC building here on campus, and we've identified an opportunity to host infrastructure in the data center, completely unused. There's a ping pong table down there. So if anybody wants to play ping pong later. So our
Good work.
our approach is to run multiple validators for multiple chains and create a pipeline between the DAO creation and LLC formation. So kind of like a choose your own service, create that public identifier and then, automatically apply it to the LLC. So that's kind of one of the cornerstones of our organization, because ultimately we're curating and funding these digital space assets, which is a new asset class. And for each new space asset we curate, the first one is Space Ranch, which is going to be a spaceport development here. So each asset we curate is going to have its own organizational DAO structure. So we're creating this infrastructure pipeline to be able to create these assets and manage them between like a multi-chain, multi-DAO structure. So that's kind of the direction we're headed and what we're working on, and hoping that we can add some clarity and definitions as we figure things out. So
Excellent. Thank you so much, John. Go ahead, Representative Stitt.
Mr. Chairman, Mr. Stokes. So this amendment we were just talking about, where if I sell my token, that at that point I automatically am no longer part of the DAO. Does that work for you?
Go
no,
ahead, John.
Okay,
No.
tell me what, and Mr. Chairman, so explain that. What problem would it create?
well, anybody can be a part of Bitcoin. You can't, whether you buy or sell or don't own any Bitcoin, you can still participate in the Bitcoin ecosystem.
Go ahead, Representative.
Mr. Chairman, does follow up. So let's imagine I sort of join Space Ranch,
Mhm.
right? And I'm happy with it. It's working out great for me. But then suddenly I don't like Space Ranch anymore and I want to get out. How do I get out?
Well,
Go ahead, Mr. Stokes.
I guess you would sell your membership or whatever. But the way we're defining our voting structure is kind of a 3-tiered. One person, one vote, that ties into the population registry that we're developing. And that's for anybody. Nobody needs to own any tokens or membership to be in the population registry and have that one person, one vote. That's for everybody. And then we have weighted voting, which is relative to your governance token stake. And then we have council voting.
So I think one of the key things here is that what you're hearing is Mr. Stokes and his colleagues are fluent in this space. They set up their own contracts. They don't need default rules. They know what they want. They did it. And a provision like the B provision isn't going to apply to them. This is good default vanilla. They didn't want default vanilla. Please introduce yourself to the committee and welcome.
Oh, thank you so much. Love Wyoming. Love what y'all are doing here. It's amazing. My name is Dane Walter. I'm also a member of the Wyo Sky DAO, and I'm actually one of the main person writing a lot of our internal legislation, like for our organization, about how the voting's working, how the vote's going to work. The idea of the one person, one vote is that anybody could participate. You could almost think of it like a bicameral legislation, right? We have the House of Representatives, which is sort of the popular vote, where every person on the planet, anywhere in the world, can participate in this vote without even having ownership of the DAO, like physical membership ownership. So you can almost think of it like the rite of passage for all human beings. In the same way that every citizen of Wyoming, once they're of age, has the right to vote within the state, right? And vote for their own representatives, whether or not they own land here or have a business here or registered their car here, right? So in that same way, we can look at DAO membership, not necessarily having to be limited to just owning a physical piece of the DAO. And so while I really support the clarification that I forget his name, Mr. Lund presented, I think that that's a really important step. we also have to be very careful not to limit the ability for people to participate in public opportunities that don't require any actual fiscal commitment or responsibility. So I just wanted to clarify that.
Yeah, absolutely. Thank you for that. Representative Stith, you good? All right. Any other questions? Well, thank you both for your presence, as well as honestly your work here in the state of Wyoming and the projects, the activity, the engagement over the years. Happy.
Yeah, happy to be here.
Appreciate everything I did.
Yeah,
Great.
oh,
Thanks.
great.
Any additional public testimony? Anything else show up online? Seeing none, public testimony is closed. Back to the committee. What's your pleasure, committee? Have a motion by co-chairman,
Second.
and we've got a second by Representative Western. All right, let's walk through. I don't have a paper copy, so let me get my digital copy up. All right, let's go through the bill. We've got a couple of amendments that I think have been raised to consider. Anything on, oh, we need a motion. No, we did that. We're good. Anything on page 2? Anything on page 3? If you're online, please, I'm not going to be able to see your hand. So if you have something, just please get my attention. Anything on page 4? Anything on page 5? We've got that little tiny typo, no big deal. De minimis, amend it. Anything on page 6? I think we've got something on page 6, right?
Yes.
Okay, who wants to make a motion on it? Mr. Co-Chairman, you tracking that? This is the, we don't want to reject, we want to administratively dissolve. Representative Stith.
Mr. Chairman, on page 6, line 3, 4, and 5, after the phrase on line 3, 30 days, delete the balance of line 3, 4, and 5 and replace with the organization shall be administratively dissolved, period.
Do we want to say this? I think we want the Secretary of State, do we or do we not? The Secretary of State shall administratively dissolve the entity, or the entity shall be deemed administratively dissolved. Which is right? Representative?
Mr. Chairman, you can put in the active voice or the passive voice, doesn't matter to me.
Okay. Any thoughts, Mr. Hopkinson? We'll just give you a flexibility to implement that amendment, get the language perfectly. We want to make sure that it's administratively dissolved and that we delete the balance of the line so that.
Yeah, Mr. Co-Chairman.
Go ahead.
I don't have it in front of me, but obviously in Title 17, you're going to find language where we point to administrative dissolution. So I would just mirror whatever we already have, whatever it says. I'd like to assume we've been consistent before when we point to, for example, failure to pay your annual renewal fee results in administrative dissolution. So wherever that's at in Title 17, just.
Sound good?
Yeah.
All right, that's considered friendly. Everyone understand the amendment?
And I seconded that amendment.
Okay. We've got a motion, we've got a second, a little bit of flexibility for David. Any discussion? Discussion, seeing none, all in favor say aye.
Aye.
Opposed, no. That motion is carried. Any other amendments on page 6? I don't think there were. Amendments on page 7. Amendments on page 8. Amendments on page 9. Representative Stith, go ahead.
Mr. Chairman, on page 9, line 14, I would move that subsection B be added with the language substantially similar to the amendment proposed by Mr. Lund and the written materials provided to the committee, with conforming changes made as LSO staff may deem appropriate.
Is there a second? Got a motion by Representative Stith, a second by Senator Cost. Any discussion on the amendment?
I just
Go ahead, Mr. Coachman.
question Representative Stith, because I don't have it in front of me, but does that square with the subsection A that says may only withdraw? What is,
If it's a friendly amendment, Representative Stith, there was a suggestion of amending A, except as specified in B below. And again, give David flexibility to provide that conforming amendment.
okay.
Mr. Chairman, that's a friendly amendment. Thank you.
So let's get it right. All right, further discussion, seeing none, all those in favor say aye.
Aye.
Those opposed, no. That amendment has carried. We are back on page 9. Any further amendments on page 9? Any amendments on page 10? This is where the staff comment starts to apply. Is there a motion on that? Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. So, I mean, we can, I don't know what the will of the committee is necessarily going to be here, but I would take it incrementally either way. So I would just make a motion to adopt the staff comment that we go through the court for petition on dissolution and start there.
We have a motion to adopt the staff comment on page 11 as an alternative to what we see on page 10. Is there a second?
Second.
Got a motion and a second. Is there any discussion? Seeing none, all those in favor, please say aye.
Aye.
Those opposed, no. That motion has carried. Go ahead.
Mr. Chairman, I would move to further amend our amendment to replace the phrase "a court of competent jurisdiction" with the Chancery Court.
Got a motion. Is there a second? Got a motion by Representative Stitz, second by Senator Furphy, to replace Court of Competent Jurisdiction with Chancery Court. That is page 11, as you see lines 19 and 20, if you're following along at home. Any discussion? And again, I'll reiterate my point. I don't want to get into this battle on this bill. I don't disagree, but I want this bill to pass, and I know how Chancery discussions go. So go ahead, Mr. Co-Chairman.
I've already, I guess, kind of weighed into, and I think, I mean, there's lots of different ways to approach it. You can amend it here. You can amend it on third reading. You can amend it here and maybe we're just hypersensitive to it, or you can not amend it here. See what it looks like on introduction, see what it looks like through 2 readings, and then on your third reading, plug it in.
Your choice, Representative. You want to do it here? Or you want to do it later?
I just made the motion. We'll just
Yep.
vote and
That's
see how
fair.
the vote shakes out this morning. And if it doesn't work today, I'll take a second swipe at it later.
Sounds good. All right. Any further discussion?
Mr. Chairman, can we just
Seeing
take a hand
none.
vote on this one?
Representative Yin, did you want to vote on that? Yes. All right. So Representative Yin is calling for a hand vote because he wants to know what's going on. That's fair. All right. All those in favor, please signal by raising your hand. To Mr. Kaufman, do you have a hand up on that?
Mr. Chairman, my apologies. I thought I wasn't a voting member for these purposes.
You're not on the final bill, I guess. All right, that's fair. That's accurate, so we won't do that. All right. So we've got 2 ayes. Those opposed, raise your hand. We've got 4 and Yin is 5. Okay, that motion has failed. And it was a good try, as indicated by Senator Murphy. Go ahead, Representative.
Mr. Chairman,
Yep.
if I may, back to page 4, lines 21 and 22, and page 5, lines 1 and 2. To be honest, I
Okay.
forgot a bit about where our discussion was, but I would make the motion to delete those lines.
All right, we're deleting and
And I can't remember if that's a good idea or not, but I had the impression that it might make it simpler and cleaner.
I think that's probably where we ended up. Go ahead. Is that a second,
I'll
Mr.
second.
Co-Chairman? All right, we've got a motion on page 4 on to page 5 to delete the C paragraph beginning on line 21. We've got a second. Any discussion? Seeing none. All those in favor say aye.
Aye.
Those opposed, no. That motion has carried. Paragraph C is deleted. Clark got one there. Yeah, he actually got most of them. All right, we are back on, we were on 11, back to page 11, on to page 12. That's mostly staff comment and effective. Anything else? Any further amendments? Any further discussion before we vote? Seeing none, roll call. All right, here, let me just do this. Hold on for the edification of my co-chairman. Let's get this right. Roll call on 22 LSO 63 working draft 0.7 as amended, decentralized autonomous organizations amendments.
Senator Furphy,
Aye.
Senator Cost,
Aye.
Senator Nethercott,
Excused.
Representative Stith,
Aye.
Representative Western, Representative Yin,
Aye.
Co-Chairman Olson.
Aye.
Chairman Rothfuss,
Aye.
that passes.
Excellent. Great work, everyone. And with that, we are taking a break until 11 o'clock when we'll get back and start discussing some genetic information privacy. Not 10:59, definitely right on 11. See y'all then. legislation that has been updated, and there's some rather significant changes to it to try and conform to our previous requests on how we wanted to see this drafted. So we'll walk through it, have some public comment, and try to work through that legislation today. We'll take a hard break at noon as scheduled, Mr. Co-Chairman, and then come back and finish after lunch if we still need more time. If the next 55 minutes or so isn't enough, we do have it scheduled for after lunch to come back and conclude. And with that, I wanted to, I should be using this one, be probably clearer on. With that, I wanted to provide an opportunity for Mr. Reville to.
Oh, thank you. I just wanted, thank you, Mr. Chairman. I just wanted to let the rest of the committee members know the reason for my absence this morning, and I'll be stepping out again this afternoon. Thanks to your good work last year on House Bill 219, there were 2 additional members added to the Investment Funds Committee. This is the sort of board that oversees the Office of the CIO and the various sovereign funds. So we're in the midst of interviewing the candidates for that. I'm one of the members of the selection panel. So we're interviewing candidates for those 2 seats. So just wanted to let everyone know. Sorry for my
Excellent.
absence.
And that's important. And actually, Mr. Reville, very briefly for the folks that are listening, because they don't hear this kind of thing, talk in 1 minute or so about our investments, the portfolio we have, and how we do it for the state of Wyoming, because I think that is an interesting and unique feature for our state.
Yeah, thank you for that opportunity. And I'll also make a pitch for some legislation that you may be seeing this year as well that will further advance Wyoming's evolution in that regard. So the state of Wyoming collectively has about $25 billion now in various pools of what you would collectively call a sovereign fund. That fund is currently managed under the Treasurer's Office by the state Chief Investment Officer, Patrick Fleming, and his staff. And they are overseen by a board, essentially known as the Investment Funds Committee, or IFC. That IFC was historically elected officials and has been kind of slowly gravitating towards a mix of elected officials as well as outsiders who are appointed by the selection panel, of which I'm one of those members. And that has, I think, led to a more professional management and more investment industry experience being brought to Patrick and his team. I think it's, for my personal opinion, is that's a good thing. And there is I believe, Mr. Chairman, a bill that will be introduced this year that would further develop the independence of these sovereign funds in terms of investment management. And I think that's a positive thing. That the investment strategy has been extraordinarily conservative historically. Wyoming has vastly underperformed benchmarks of other sovereign funds or endowment funds, not because of any mismanagement on the part of the officers, but because of the rules by which they're bound and assets that they're able to invest in. So I think the opportunity to invest in a broader group of asset classes would be a welcome change.
Absolutely. Thanks. Any questions? Go ahead, Representative Western.
Mr. Revelle, it sounds like you're chasing higher returns for Wyoming taxpayers.
I think that would be, I mean, this corpus, and I think there may be lots of different views on it, but I think is in and of itself a source of revenue, or needs to be viewed as a source of revenue. And the management of that corpus can lead to greater returns, which would lead to more significant revenue for the state in the future. And so, yes, sir, I fully believe that.
Absolutely. And one thing that you and I have discussed that I hope the investment advisory group takes a hard look at is investing in cryptocurrencies during the next cycle, where we have a process that sets a portfolio and then the investment portfolio is used to guide our investments for that year. We do have flexibility in statute that would provide for an opportunity to invest in cryptocurrency if that is part of the portfolio. That was legislation from a few years ago where we provide that as an acceptable or permissible investment. And I'm hopeful that with the progress that we've made, and I think with some of the research that I know you and I have talked about, that's something that will blend into our portfolio over this next year. if we do anything along those lines, we want to hear back from you on it. Go ahead, Mr. Reville.
Thank you, Mr. Chairman. Great comments. And I would add that it was not until recently that equities were a permissible investment for this sovereign fund. And you are still, Mr. Fleming's office is still not able to invest in venture capital, which is one of the reasons for the underperformance versus peers. So I think giving the CIO greater latitude and more resources would be a wise thing for the state of Wyoming long term.
Agreed. On this topic, any further discussion? So please, Mr. Ville, step out as needed and make sure that you carry out those responsibilities.
Thank you, Mr. Chairman.
Thank you. All right, back to top. So David, let's go through the draft legislation because it is rather significantly updated since the last time we met to comport with our requests and walk through the current structure.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, walking through 22 LSO 291 Working Draft 0.7. This version is significantly different than the version the committee looked at last time. That version primarily had repealed existing Wyoming law and replaced it. This version is more of a merger of existing Wyoming law and new language. The staff comment highlights one issue I would just point out as you're looking at this. I did include the entirety of Wyoming's existing law in the final version of the bill. Much of that will be cut out because that pursuant to our staff or our drafting conventions, we don't include any statute that's not changed, but that's here just for your consideration and to compare and see what the law in its entirety is really doing. I'm going to come back to section 1 as that applies kind of at the end, and we'll just start at section 2 and walk through what this bill has here. The first change we'll see is 3532-101 on line 14, as used in this chapter unless otherwise defined, and that was an effort to kind of there is some language in here, particularly when looking at informed consent that is defined in various ways. And so that was just kind of attempting to capture that concept that sometimes, depending on how it's specifically applied, it might be slightly differently defined. The rest of those definitions are in existing statute. And I'll jump down to where we see some new language. We've got in a new paragraph 7 on page 5, definition for biological sample, definition for consumer, who is essentially a natural person in the state of Wyoming, a resident of the state of Wyoming. And this is all language that we would have seen in the last walkthrough of the bill. Definition for what de-identified data is. Definition for direct consumer genetic testing company, express consent, genetic data, and genetic testing. And I want to take a closer look at some of these. One item for the committee's consideration is I was putting this bill draft together and kind of merging the concepts that we see across these. I did leave in a definition for genetic information, as well as we see the new definition for genetic data. There is significant overlap. The committee may wish to consider it might be more prudent to merge those two definitions and have just one definition. The same thing with genetic analysis and genetic testing. There is some pretty significant overlap there, and it may make more sense rather than having two separate definitions throughout the bill to make those one consistent definition and apply that throughout the bill. On page 7, getting into 3532-102, genetic testing prohibitions and exceptions. Again, this is existing statute that provides kind of what Wyoming's existing law in this area is. Particularly, I think the core of that law we see in section A there, subsection A, that provides that no person conducting genetic analysis shall do any of the following without informed consent. And those 4 paragraphs there, they shall not obtain genetic information, perform genetic analysis on an individual, retain an individual's genetic information, or disclose that individual's genetic information. And I think existing law, that's kind of the highlight or what this is built around. Subsection B there provides for the exceptions, and there's a lengthy list there of exceptions for things such as registration of sex offenders, collection for law enforcement purposes is otherwise authorized by law, et cetera. And that goes through onto page 10, all the way through to paragraph 12. New language in a new subsection C, and this is where we would kind of get back into what the previous draft had done. And it provides that to safeguard the privacy, confidentiality, and integrity of a consumer's genetic data, a direct-to-consumer genetic testing company shall. And it provides a list of the things that they shall do, provide a clear and complete information regarding the company's policies and procedures for the collection, use, or disclosure of genetic data made by making available to a consumer. Then it lists some requirements of what they have to make available, such as the high-level privacy policy that includes essential information about the consumer's collection, use, or disclosure of data, and a prominent publicly available privacy notice that includes at minimum information about the company's data collection, consent, use, access, disclosure, transfer, security, and retention and deletion practices. Provides that they shall obtain a consumer's consent for the collection, use, or disclosure of the consumer's genetic data, including at minimum initial express consent that describes the uses of that genetic data that's collected, separate express consent, and I'm on page 12 now, subdivision B, separate express consent for transferring and disclosing that consumer's genetic data to any other person other than the company's vendors and service providers, a separate express consent for the retention of any biological sample following the completion of the initial testing service requested by the consumer, informed consent in compliance with federal policy for the transfer and disclosure of the consumer's genetic data to third parties for research purposes, separate express consent for marketing to a consumer based on the consumer's genetic data, or marketing by a third party person to a consumer based on their having ordered or purchased a genetic testing product, test, or service. Requires valid legal process for disclosing genetic data to law enforcement or any other government agency without a consumer's express written consent. Requires that they develop, implement, and maintain a comprehensive security program that protects the consumer's genetic data against unauthorized access or use or disclosure. And that provides a process for a consumer to access the consumer's genetic data, delete the consumer's account and genetic data, and request and obtain the destruction of the consumer's biological sample. Subdivision, or excuse me, subsection D on page 14, new language provides that notwithstanding any provisions in this section, a direct-to-consumer genetic testing company shall not disclose genetic data to any entity offering health insurance, life insurance, or long-term care insurance, or to their employer of the consumer without their written consent. A couple of things I want to highlight about this, and one more suggested amendment for the committee's consideration when that time is appropriate. On page 10, line 17, subsection C, the committee may wish to consider including a notwithstand or except as otherwise provided or prohibited by subsection B, if the committee wishes to include all of those exceptions in subsection B that are seen on page 8 through 10, to include those exceptions and have those apply to the genetic testing company. Back on page 14, 3532-103 just provides for the inspection of genetic information about an individual, and that the person conducting genetic analysis shall destroy the individual's genetic information upon request of the individual or the individual's authorized representative, unless it was obtained pursuant to those exceptions that we see in 3532-102B, or that retention of the information is necessary for a purpose disclosed to the individual or representative in the informed consent. And then paragraph C or subsection C just provides that that information shall only be used for the purposes for which it was obtained. 3532-104 provides for the criminal penalty. Again, this is existing statute. With the exception of some new language we see on page 16 that provides that prior to filing an action, the consumer shall give notice in writing, and it essentially gives an opportunity 60 days to cure a violation before they bring a civil action. And then it provides in subsection C, provides for the Attorney General to bring an action on behalf of the state or on the person to enforce this chapter. And it would be specifically limited to consumers to enforce this chapter, meaning a Wyoming resident, a natural person who is a Wyoming resident. With that, Mr. Chairman, I would certainly stand for any questions, any clarifications. There is kind of a lot going on and a lot of overlapping, so happy to help however I can.
Excellent. Thank you, David. Appreciate it. Go ahead, Representative Stith, questions.
Mr. Chairman, Mr. Hopkinson, thank you very much. Can you paint a picture for us for how the new language on page 16, lines 3 through 10 would work in practice? So imagine a scenario where the genetic testing company violates the act by, say, providing all of my genetic information to my healthcare insurance company and to my life insurance company. And they see that I've got all these genetic markers. And so I get either turned down for health insurance or for, well, I guess life insurance might be a better example. So I get turned down for life insurance, or the premium is really, really high. So they violated the act. I learn that. I write them a notice. I say, hey, you gave my information to the life insurance company. Fix that. And then if in 60 days, within 60 days, they call up the life insurance company and say, oops, sorry, we didn't mean to do that. Then it seems this provision says that if they've so-called cured it by withdrawing the information somehow or having that file deleted within the life insurance company's database, for example, then I can't sue the genetic testing company. I don't have a right to bring a civil action at that point because they've cured it. And yet the bell has already been rung and the insurance company is still going to deny my life insurance policy. Is that how this works?
David, what are your thoughts?
Thank you, Mr. Chairman. Representative Stith, I do think that that could be a fair concern with this language. You know, and what exactly is a cure? Is it just simply retrieving that data from the company and then saying that that's all that they can do or needed to do? I think that is a fair question.
Representative Stith, I'd ask you the same question because I mean, what is a judge going to decide as a cure? That doesn't sound anything like a cure to me. But it's then going to be interpreted by the courts as to whether or not you've just cured it.
Mr. Chairman, if without this language, it seems that there's an opportunity to bring a suit for civil damages. But if the company says we've cured this because we've now forced the life insurance company to delete this information from its own database, for example, they'll claim that it's cured. And now I don't have a right to bring an action at all, I think is what this language says. Whether I'm damaged, so even if I've suffered some kind of monetary damage, my right to bring an action is extinguished by the cure by the company, is how it seems to read. Maybe I'm not reading this language the way it's intended. I don't know.
I think you're reading it the way it's intended. I just would, I mean, it's going to be up to the court to decide whether or not your suit is in order, which would then be their judgment as to whether or not that was a cure, like at face value, or whether it was an insufficient cure. In other words, if you still have damages as a result of their actions, then they haven't necessarily cured it. Is the court going to take it the way that you first suggest? Do we not know? Why do you suspect that would be considered a cure? I just wouldn't think of it as a cure, but again, you've got more experience in this space than I do.
Mr. Chairman, I don't have any experience in the space of curing what
Okay.
amount to privacy violations, because if, or a different example, what if inadvertently all of your genetic information just gets posted to some social media site for some amount of time, and they cure that by taking the post down or having the post removed? I mean, the company at that point has probably done everything it could in terms of just removing the information, but once you ring, how do you unring a bell, I guess? What is a cure? I don't-
Good question. Ms. Long, go ahead.
Thank you, Mr. Chairman. Question for Mr. Hopkinson. The right to delete the account and request that the data that was previously voluntarily provided by the consumer be deleted. Is that only applicable from the date of the effectiveness of the law, or would that go backwards in time to people who already had accounts at these genetic information companies?
Good question. Mr. Hopkinson, what are your thoughts?
Thank you, Mr. Chairman. The section 3 does provide that the act shall not apply to contracts for direct-to-consumer genetic testing entered into prior to July 1st, 2022. So I think there may be an argument to say that, depending on the circumstances, frankly, that they wouldn't have to delete it pursuant to this act if their contract provides otherwise. But, and this is where we kind of get into some of the other overlap, existing statute, which would require, I think, already for them to delete that unless it was acquired pursuant to one of those exceptions, the 13 exceptions or 12 exceptions. So if it wasn't, I think under existing law, they already could request that they delete that data.
Yeah, and that would be my take on it as well. The existing law was intended to cover the same situations, but a lot of the additions for the direct to consumer, in fact, strengthen, I think, what we previously had. As I read it, it tends to get better. So your protections previously would not be obviated in any way. And hopefully, there's some good protections in place. But at the end of the day, one of the concerns that we share, having brought this legislation, is that it still is not great, sufficient protection. And, we're trying. I think this is moving it in the right direction. But again, I don't know that we will achieve perfect. It'll be a real challenge. Go ahead, Ms.
Mr.
Long.
Chairman, just to follow up, it may make sense to propose a friendly amendment as a non-voting member. I can't do that, but something that says, notwithstanding the effective date of the act, that makes it absolutely clear that this doesn't obviate the past protections. And in fact, actually, the right to delete the information does actually go to any information that was ever provided.
Yeah, I don't think we need that, honestly, because I don't think there's any way that a court could interpret it that way. I could be wrong. What are your thoughts? That's just not how things go statutorily. It's in effect up until the moment it changes. The new is in effect, and so that would govern the new contracts at that date. The prior statute that would be in place at the time that you signed the contract would be governing, I would expect. Mr. Hopkinson, do you have any thoughts on that?
And Mr. Chairman, I'm just going to flip to that provision. So the existing law we've got, and I'm looking on pages 14 and 15. So subsection B provides that a person conducting genetic analysis shall destroy an individual's genetic information upon request. Unless, and again, we've got the exceptions in B, and if it's necessary for a purpose disclosed to the individual. So under existing law, you could request already that they destroy that information unless paragraph 1 or 2 applies. With the new law, I don't think that it doesn't, those sections are still there, so that they remain. So they could still request that unless one of those 2 exceptions applies. So I don't think it really changes what's going on. This new law, it doesn't affect that.
Any follow-up? Go ahead, Ms. Long.
Just shifting gears, it's worth noting that the conversation we had yesterday about the third-party doctrine actually applies here as well, because, and I love the fact that you added the requirement that the government, when they get this genetic information, must provide a warrant. This is a place where we're outside of the Bank Secrecy Act now, and we as a state are not federally preempted, and we can protect the Fourth Amendment rights against that third-party rule. And again, just as a refresher, the third-party doctrine is a Supreme Court upheld doctrine that is being carved back, thank goodness, by the Supreme Court, that says that anytime you voluntarily give information to a third party, that you no longer have an expectation of privacy in that information. It's an outrageous doctrine. And with genetic information, it is absolutely critical that we carve back that third-party doctrine and create protection. So kudos to you for drafting it this way. Thank you.
Go ahead, Mr. Co-Chairman.
No, I was going to say representative.
Oh, I'm sorry. Thank you for that. Representative Yen.
Thank you, Mr. Chairman. So, Mr. Hopkinson, excuse me, question on the genetic data and genetic information definitions. For merging it, do you have any suggestions that are workable, or could you just delete the genetic information definition and replace all instances of genetic information with genetic data? Any thoughts on how to best merge that? Thank you, Mr. Chairman.
Go ahead, Mr. Hopkinson.
Thank you, Mr. Chairman. Representative Yin, I do think it would likely be easier to conform genetic data and keep that and replace genetic information. And for the most part, I think it probably would make sense to simply delete genetic information and replace that with genetic data throughout the bill.
Representative Yin, go ahead, follow up.
That's all. Thank you, Mr. Chairman.
Great. The one difference there, and this is a concern we'll discuss, I think, with the folks that represent the companies, is the idea of the family data as opposed to the individual data. So we tie in genetic information, details about information about the genetic characteristics of an individual or members of an individual's family, because you gain a lot of secondhand information when if somebody has my genetic information, they've got an awful lot of information about my family at that moment. And so as originally drafted, that was contemplated. The revised language, I don't think necessarily gets at that. So we'll need to discuss how to manage that if we're integrating the two concepts. But otherwise, in every other way, I think, for example, genetic data as defined here is better than the definition of genetic information. It's more complete, technically accurate. And I think our genetic testing versus genetic analysis, which is in the same situation, our old definition of genetic analysis is very similar to the genetic testing, and one could easily, genetic testing could easily replace the previous. So I don't think there's any real danger in consolidating, with the exception of the conversation about the family information that you gain from having my genetic information. We'll see how that discussion. Other questions on the draft? Go ahead, Senator Cost.
Thank you, Mr. Chairman. I guess I'd refer to Mr. Hopkinson on it. I kind of look for definable terms, and are things definable? And I look back to what Representative Stiff was talking about with the cured. Is that a definable term in the terms of lawyers, or is that something that you could have more definitions on? So cured isn't really definable by everybody the same way. You know what I'm saying?
David, thoughts?
Thank you, Mr. Chairman. That is an area that I would need to do some more digging as far as how might a court interpret cure? What does that include damages? I'm not sure at this point. But I could certainly dig into that for the committee. Now, do I see any issue on its face with defining what constitutes a cure in this particular statute? I don't think that's a problem either. We could provide that and tell the court what it should be.
That's an interesting idea. And I think, and we can ask when we have public testimony, but it's my understanding that HIPAA provides for a lot of opportunities for cure as a remedy. And I think this is sort of stemming from HIPAA type concepts, but let's look into that a little bit more and find out how much case law is already out there regarding cure. Any other questions? Representative Yin, did you have anything else? All right, any other questions before we go to public comment? All right, seeing none, let me see what we've got. I don't think we have any executive branch. I think we have all public comment. All right, public comment is open. If Dave, you want to come up and bring your team, anybody that wants to join you, you're welcome to join. Yeah, are we doing the presentation? I think we're doing the presentation. Is that right?
Are you doing a presentation, right?
That's what I thought. Okay. So let's get that hooked up and do you have what you need to present from LSO? Are we set for that?
Mr. Chairman, members of the committee, Dave Pickard representing Ancestry.com and 23andme.com. I do believe that we have everything ready to go.
Great.
It's what would your pleasure be? I'm looking at, it's 12:37 or 11:37. I understand it's a definite hard break at noon.
It's not that hard. I'm just saying that we're gonna stop at noon, go
Okay.
have lunch, and then come back is the
So,
plan. So
Mr. Chairman, what's your pleasure? Do you want to proceed with the demonstration of all the consent and the sign up before we get into the meat of the bill?
how long would that be? I assume it could probably be done in around 20 minutes. That'll work before lunch. Is that fair?
Yes,
Yeah,
Mr.
all right,
Chairman.
great.
How do-
If that's the case, let's do that now, and that might
Okay.
lead us into lunch.
Sure, Mr. Chairman, I'm going to turn it over to Jackie Cook Haggerty, excuse me, with 23andMe. I'll let her introduce herself.
Good morning, Mr. Chairman and members of the committee. I am Jackie Cook Haggerty. I am Vice President of Legal and Privacy Officer for 23andMe. Thank you for having us back here again today. So I'm going to attempt to share screen.
Yeah. Looks like it's working. Great.
And okay. So wanted to walk through our kit registration and consent flow and give the committee members a feel for exactly what it is the consumer experience is to illustrate our adoption of the best practices and how information is presented to the consumer. So the first thing a consumer does when they receive a kit, they have to first create an account in order to register a kit. So you do that here by providing name and password information and date of birth. The date of birth is important for clinical laboratory purposes and is required in order to comply with federal CLIA regulations. And once the account is created, the individual is prompted to enter the barcode from their saliva collection tube. So you would click whether you were using the kit yourself for someone else that might be in your profile or someone else entirely that you need to provide information for. So the first thing presented to the consumer for review and acceptance is the terms of service and privacy statement. In order to view these full documents, you would click through into those hyperlinks here, which are presented multiple times throughout the document, but consistent with what you see in the legislation that is before the committee, there is a highlights portion of what is in our privacy statement that presents how information is used, what information is collected. This is really succinct delivery and presentation of the information for individuals who may not want to read the full privacy statement, but for them to be able to understand the categories and additional detail on these different collections and uses of information. Here, and in our product, this is a single scroll down. It's not clicking through documents in this way, but was easier for this presentation. Information about the control that the consumer has and the choices that are presented to them for use of their data or sample storage. You'll see that later in this presentation. And then also key information about how information can be accessed or shared, and specifically that it's only shared with service providers in order to process the individual sample and provide the service to the consumer. And to the extent an individual participates in our research program, de-identified aggregated information can be shared with qualified researchers. Here we make, again, the commitment that we will not share information with public databases, any insurance company or employer, or law enforcement without a consumer's separate explicit consent. Finally, information about how we secure information and key risks and considerations in using our services. We want to make sure consumers have this information before they accept and agree to proceed. So they do that by clicking there on the blue button. And once they move past that, there's the research consent document that's presented to them for consideration. This is entirely optional. This is, as we discussed briefly at our last appearance before the committee, is regulated and subject to federal regulation for the protection of human subject research. We work with an independent ethical review committee to review this, and ultimately it is approved by them to ensure that there is that third-party validation that this complies with federal regulations. So key information here about our research program is presented, why our company does this research, what it means to take part in the research, privacy protections that we have, who has access to the information that is contributed to our research program should the individual choose to participate, and the benefits and risks of taking part in the research. We here also stress that the individual can change their mind at any time and the implications of doing so. An individual can opt in or out of participating in research at any time that they're a customer of 23andMe through the account settings in their product experience. So here is the final consent boxes where the individual chooses whether or not they give consent, depending on whether they are the individual that is actually doing the test or consenting on behalf of someone they have legal authorization to do so. So if an individual does not give consent, the next couple of consents that are presented will not appear, because this is the gate for a couple additional options that an individual will have, but only if they participate in our research program. And this reflects that there are different ways that an individual may want to share and contribute their data to research. We don't make it an all or nothing consent in that regard. So one of those ways is to be able to contribute their individual level data to research, and that would enable the company, if there was a compelling opportunity, to be able to share that individual's de-identified genetic information or phenotypic information, that's self-reported information, with a third-party researcher. An example of where we've done this in the past is in a collaboration with respect to Parkinson's disease. The Michael J. Fox Foundation, individuals who are part of that community have the option to contribute their individual level information for further research by collaborators who are participating in that research collaboration. So this is the rest of that particular consent, and the individual here again makes a decision on whether to give consent or not. And this is the second research consent that's related to the main research consent. Again, if you don't consent to research, you won't see this as an opportunity. This is our research consent where you authorize us to contact you based on unreported genetics. So you might have a genetic variant where 23andMe does not yet offer a specific report. And this might be something that comes up in the case of clinical trial recruitment where, a genetic variant can be meaningful with respect to defining a patient population. A drug may work better for individuals with a particular genetic variant as opposed to not. So this, if you're interested in being able to be contacted based on that type of information, you can consent to do so here. And then here is our biobanking consent. Again, this is a choice that the consumer has and doesn't impact their receipt of the 23andMe service, whether or not they want to store their sample with our third-party lab. So this is the final screen where you review the decisions you've made with respect to those consents and complete registration.
Excellent. Thank you so much. Questions for Ms. Haggerty? Representative Stitt, got one. It looks like you got one.
Ms. Haggerty. So if I understand it right, if we adopted the proposed legislation as presented to the committee, would 23andMe need to change anything about how it's currently doing business as shown on the presentation?
Ms. Haggerty, go ahead.
Thank you for the question. Thank you, Mr. Chairman. No, we would not. This complies with the legislation as proposed.
I'll ask a follow-up question on that. I think it's, as I understand it, you comply with our existing statute, but our existing statutes are the terminologies we use, some of the things cause some conflict of definitions with, and is that accurate? Can you talk a little bit about why our existing statute, while you're compliant, is not sufficient for the interests that you're representing?
So there, thank you, Mr. Chairman. A couple reasons that we're seeking amendments. A, to strengthen the protections, frankly, for consumers in Wyoming and also make it applicable to third-party interpretation services, not just to direct-to-consumer genetic testing companies. Additionally, we're hoping to be able to have consistency across states with respect to definitions.
Excellent, thanks. Any follow-up, Representative Stitt? Good on that? Okay. Committee, anyone else have any questions on the presentation of the material? Representative Yin, questions? No. Okay. Back to you. Go ahead.
Thank you, Mr. Chair, members of the committee. Rishi Engelhardt, Senior Director and Head of Government Affairs with Ancestry. I have a very similar presentation, so I can run through our consents and you can see that they are going to be very similar to 23andMe's. They are compliant with existing statute and proposed statute.
Great.
So I am just going to try and queue this up and I will run through it pretty quickly since we got a lot of detail from Jackie and we won't need to belabor that too much. So perfect. Just for fun, my privacy settings are forcing me to reboot Zoom so that I can share my screen.
Of course they are.
Give me 1 second, I will jump back into the meeting.
Mr. Chairman, while he's
go ahead.
getting that up on the screen, I'd like to mention that after our last meeting, I had the opportunity to subscribe to both services. And both of them are very similar in how they present all the consents. And what I liked about both of the platforms is that much often when you're signing up for something of this nature, you want to sign up quickly in order to get the sample package to you. And so I could either consent at that time to all of these, or I could go ahead and get signed up and then go back in at a later date and opt into a lot of these options. So you went in, I went in and I entered all of my information in order to get that test kit. Then the test kit came and I went through all the consents for how the sample is going to be utilized at that time. And I thought it was very simple.
Great.
I also, in the case of 23andMe, I didn't consent to some of the research products. And then I was able to go back in, thought about it for a couple days, went back in and consented. And my sample is still in process, but I have consented to some of those research products.
Excellent. Thanks. All right, looks like you're ready, Mr. Engelhardt. Go ahead.
Up and running. So we're going to pick up with the Ancestry activation flow after a customer has created an account and reviewed terms of service, which were the first couple of slides on Jackie's. Those are very similar. This is just for someone who's purchased a DNA kit and wants to get that activated. So this first slide, you have to be signed in. This person is signed in as test order. That is the name of the customer. And then you have to click next. The very next slide asks you to enter your activation code. That code is on the vial that you provide your biological sample and will be linked to your account so that your test results go to the right person. In this next slide, you have to affirm whether the test is for you, a child, or someone else that you have legal authority to consent for. And if you don't affirm that, you cannot continue from this screen. And then you have to tell us a little bit of information about yourself, your first name, date of birth, and your biological sex assigned at birth. And this, again, is so that we know that the laboratory is processing the right sample and helps us with the validation process at the lab, which we explain in a pop-up, as you see on the next slide. So for the processing consents, this is where we really kind of get into the meat of what's in the bill. Before we will process a biological sample, you have to give consent for processing, and you're informed of all of the following things on this screen. That the processing will be used to deliver the service or product that you've asked for, namely your ethnicity estimate, as that's Ancestry's bailiwick. We don't really do the health reporting anymore. We got out of that business about a year and a half ago. The processing will be used to link you to other Ancestry members whom you're related to. And you'll see in an upcoming slide that we don't reveal those connections unless you consent and the other party consents to see them. But as part of using the service, we have to figure out where you fit into the family tree that we keep going on the DNA side. And also that the processing may be used to provide additional hints on your family tree if you subscribe to that service with an Ancestry. So basically, the genetic tests that you are taking can talk to your information in your Ancestry.com account. Also, that Ancestry may use your data to develop new services and improve our product offerings. This never involves sharing your data outside of Ancestry, but we look at your genetic information based on other information you've provided to make sure that when we're providing an ethnicity estimate, that it is as accurate as possible. So this next slide is on sample storage consent. This is what 23andMe refers to as biobanking. We will not store your sample unless you give us consent to do that. And as referenced in the bill, you have the right to revoke that consent and have your sample destroyed within 30 days if you change your mind at a later time. Informed consents for research are on the next slide. Very similar to 23andMe, we have this in a pop-up where you have to open the informed consent and scroll through it. We can't really force people to read, but we know that they have at least reviewed those panes on the computer before they're allowed to provide the informed consent. Very similar process. It's IRB approved. We actually do not have any current research programs at the moment. We have plenty of folks who have opted into research, but we are not currently doing any research programs at this time. So the next screen I referenced a little bit earlier, this is on DNA matches, when we explain that you have to consent, the other party has to consent before that match is revealed. And we also allow you to decide how much information those matches see. Do they just see the strands of DNA that overlap between you and them? Are they allowed to see all of your different genetic strands that are in the system? And then you also get to choose how you send messages to each other, whether it's, just on the site or by email or by text. So the next screen, this is how you will be viewed by your DNA matches. So some folks don't have an issue with their full first and last name. Other people would like that to be limited to just their username that they use to log into Ancestry. And given that these matches are very personal, we let you decide how much information and how they see you on the site, should you be a match and should you consent to see matches. Ethnicity estimate display. This is again what I referenced earlier, where you decide how much information the person sees when you match, if you've opted into that. And then we get into some other consents that really are outside the scope of the bill a little bit, where this is how do you want to receive information as your kit's being processed. So the default is that we will send that information by email, but we will send you text if and only if you consent to that. If you do consent to that, you have to provide the phone number that you want us to send those updates to. So even beyond how we triage genetic data, we're very sensitive that we don't want to bother folks in ways they don't want to be bothered as they're using our service, and we get those consents for those things. And then should you have updates to your ethnicity results as we get more information and learn more about how different parts of the genome have migrated across the globe over time, or you have new matches or new insights, you get to decide whether you get that in a digest email, if you get them immediately. Again, we want to make sure that if we're sending folks information about their DNA, that they've consented to how they receive that information and in what cadence. And then these last couple of slides are just review. After you've made all of these choices, we go through and make sure that you can review everything that you've consented to, that the information is correct. And once you've decided that that is correct and that is how you would like to interact, you hit submit and activate, and your kit will be sent off for processing. So welcome to take any questions from the committee.
Excellent, thank you. And easily before lunch too. Any questions on the presentations? One I have that I'm curious about, and for both companies, is the destruction of the genetic information versus the destruction of your processed material related to the genetic information. Like the ethnicity is a great example. So you can still have that information in your database and know who this person is related to after you've destroyed the underlying information. Do you have those tiers of deletion available where I can say, for example, I want you to get rid of the genetic material and even the underlying genetic data, perhaps whatever sequences that you've got coded, while still keeping me in the ancestry tree from your perspective? Is that a viable option? Is that a path?
So thank you for the question, Mr. Chairman. There's a couple things at play here. So if you tell us to delete your genetic information, we will delete all of that. If you have found family members in the process of participating in the DNA product, and those family members have added you to their family tree, they're not adding your genetic information, but they are adding the fact that you are their third cousin and whatnot. So information that you let others add to the family trees, that doesn't delete even if you leave the service, right? Because that is them basically saying, Joe Smith is my third cousin, and this is where he fits into my family tree. There's no genetic information that goes into their tree when they do that, even though the genetic information may have been used to reveal that relationship.
Ms. Haggerty, do you have anything to add to that?
Yes, Mr. Chairman. So for 23andMe, the request to delete your information necessarily comes with closure of your account. So there wouldn't be any option to maintain the sort of relationship information that Ancestry.com has. We don't have a family tree feature that would support that. Yeah.
Thank you. Any further questions? Further questions? Representative Yin, I see your hand. Go ahead.
Mr. Chairman, thank you. Mr. Engelhardt, nice to see you again. Sorry it's not in person. For the bill draft, so when we had this conversation with LSO about merging genetic data and genetic information definitions, would there be any concern with adding consumer's family to the genetic data definition so we can clean out the genetic information definition for both, and I guess that's a question for both you and Ms. Haggerty. Thank you, Mr. Chairman.
And that might be a deep and complicated conversation for after lunch. Is that something that we should go and discuss after lunch? That's what I thought. Representative Yin, can we hold that one since we've hit our 12 noon? We'll come back and we'll probably start right into that one because I do think there's a lot of discussion about how we appropriately engage in that space and get the legislation in shape with regard to family members.
That sounds great.
All right, any other final thoughts or comments before we break for lunch? All right, seeing none, thank you. Appreciate the presentations and we look forward to seeing you at 1:30. We'll be back starting up again at 1:30. See you all then.